The witness has been reminded that he's still under oath, my lady.
Thank you.
As it pleases the court, my lady.
Mr. Vani.
As the court pleases. Mr. van der Westhuizen, just let's start with a small matter. Yesterday you said you recalled Mr. Ford Kalata because you associated him with the Ford Motor Company.
Meneer van der Westhuizen, kom ons begin hier met 'n geringe saakie. Het gister aangedui dat u vir Ford Kalata ken omdat u associeer met de motormaatskappy Ford hier in die baai. Is dit so?
Dat is correct. Die commandant het 'n baie nauwe verbintenis met die Ford maatskappy gehad.
Yes, John.
That is correct, so, my lady.
My lady, may I just... Sorry, Mr. Finish.
Sorry. It is correct, so, because Mr. Ford Kalata had a very close connection with the Ford company. Thank you.
Yes.
Lady, now, with respect, the interpreter did not translate the answer correctly. It was not Mr. Ford Kalata that had a close connection with the Ford company. The answer was that the Eastern Province Commandment had a close relationship with the Ford company.
Please, let's keep the noise down, please. Yes, Mr.
Thank you, counsel. Can you repeat who had a close connection with the Ford company? Wie het daarna 'n verbintenis gehad met die Ford maatskappy?
Ek kry die name per se onthou nie onteedele. Ons het met verskeie maatskappye baie goeie verhoudings gebou. Hulle was een daarvan.
I can't know the names clearly now, my lady, but we had a relationship that we built up with the various companies, and he was one of them.
Is that the Ford company? Is that the Ford company now?
As that nou die Ford maatskappy, as he said, is een van hulle. Is that the Ford company?
Dit is die Ford maatskappy wat motorvoertuie ontwerp en hulle het 'n baie groot fabriek aanleg gehad in Port Elizabeth.
That is correct, so my lord, that is the Ford company was manufacturing vehicles. They had a very great company in Port Elizabeth, my lady.
Well, this is just a small matter which is not material, but just for the record, Mr. Ford Kalata was named Fort by his grandfather, Canon James Kalata. He was a senior ANC official, and he named his grandson Fort because at the time he was detained at the old Fort prison in Johannesburg.
And that is correct, so want Fort Kalata se oupa, Canon James Kalata, het van die naam gegee met die ontstaan van die Fort motormaatskappy, en hy was ook in gehegtenis gewees in Johannesburg en ook in 'n inrigting Fort Kalata.
Did that come
correctly? Dit nie dis 'n geringe saak.
Lady, may I just mention before Mr. Varney proceeds, we do not have image of the court or of Mr. Varney on our screen. I don't know if the cameras are not on or there's a problem, but we can't see yourself nor Mr. Varney.
Okay, I'm told that is being attended to. Would you mind if we continued in the meantime? Or does it
Yes, no problem.
All right.
No problem, we might continue.
Thank you. It looks like this is going to take us a long time, Mr. Vani.
Yes,
if
yes.
you say it's not material,
It's
is it
not
okay
material.
if we...
Milady, with your leave, I'd like to continue. Mr. van der Westhuizen, I'd like you to tell us a bit about the security apparatus in Port Elizabeth in 1984 and 1985. You were the commanding officer of Eastern Province Command. Can you describe the structure of military intelligence at that time?
Meneer van der Westhuizen, ek sal graag verlang dat u vir ons kortliks vertel die Port Elizabeth en dit van 1940 en u was die bevelvoerder van die die Afghaanse militaire mag.
Ja, dit is 'n groot organisasie geweest.
Yes, it was quite a big organization which I briefly wish to explain. In total,
mannen beslaan.
It was comprised of 30,000 men.
Sorry to interrupt, Mr. van der Westhuizen, and just to save time, the question was not about Eastern Province Command as a whole. It was only about military intelligence, and perhaps let me just ask you, was Lawrence du Plessis, between 1984 and 1985, the head of the section of military intelligence and ComOps?
Die vraag gaan nie oor die hele provinsie nie, maar dit gaan oor die militaire intelligensie. En die vraag is, was meneer Lawrence die hoof daarvan?
Ek verstaan hulle reg, Lawrence du Plessis was lid geweest van die inligtingskomponent by die kommandementhoofkwartier.
And I understand the question correct, sir. Lawrence du Plessis, he was the head of the information. The general is shaking his head. I'm missing something, General. Ek sien, is kat ek op, kan u weer kom?
Ja, ek het nie gesê hy was die hoof nie, ek het gesê hy was 'n lid van die inligtingskomponent van die kommandement.
Dankie. I did not say he was the head. I said he was the member of the information component. Dankie, generaal. Kan ons voortgaan?
And was part of the role of the intelligence or information section to engage in activities which would undermine those involved in the liberation movement and their organizations.
So dit was die plig van die inligtingskomponent om te ondermyn die aktiwiteite die wat betrokke was in die onluste. Is dit so?
Die inligtingskomponent het nie operationeel opgetree nie. Hulle het inligting ingesamel of informasie ingesamel en verwerk na militêre inligting toe.
My lady, the information component did not actually act or carry out duties. They only collected information which they forwarded to the military necessary components, intelligence.
But was military intelligence in Port Elizabeth at the time not engaging in deceptive activities such as setting up or helping to set up organizations, for example, the Uitenhage Concerned People's Organization and the Actie vir Voorspoed en Vrede.
Nou, is dit nie so dat die militaire intelligensie mag met bedrieglike aktiwiteite voorgegaan soos in Uitenhage, die Concern Groep, en wat is die ander ene? En
Actie vir Voorspoed en Vrede.
de actie voor voorspoed en vrede, dat is action for success and peace.
Ek kan nie per se 'n aksie vir voorspoed en vrede onthou nie. Die inligtingsafdeling het covert en covert inligting versamel.
My lady, I can't recall actie for voorspoed en vrede, but the intelligence component were gathering information, my lady.
And as part of the covert operations of military intelligence, probably cooperating with the security branch,
Nou, as deel van die intelligensie, van hulle werksaamhede, ook aan hulle samenwerking met die veiligheidsmag, of veiligheidstak.
can I ask you just to wait until I pose the question? So as part of the covert operations of military intelligence, probably working with security branch, they engaged in operations such as printing of pamphlets.
So hulle het aan aksies betrokke geraak waar hulle pamflette uitgedruk het.
Correct?
Is dit korrek so?
Dit is korrek, daar was wel pamflette gedruk in so getuigweek in operasie Katzen, waar daar pamflette oor Gqeberha gedruk en versprei is. Dit is byvoorbeeld wat die inligtingskomponent hanteer het.
That is correct so, my lady. There were pamphlets that were printed, for example, as some had the image of Gqeberha, and that was what the information component was dealing with as they gathered information.
So it's correct to say that military intelligence was engaged in deceptive activities in helping to create such organizations and give the impression that these organizations were supportive of the apartheid regime.
So, dit is correct dat die militaire intelligensie besig was met bedrieglike aktiwiteite deur hierdie organisasies in die lewe te roep ter versterking van die destydse regering se beleid.
Edele nee, ek kan dit nie aanvaar nie. Alle weermagte in die hele wêreld het 'n inligtingskomponent wat inligting insamel oor sy gebied en die mense en die aktiwiteite in daardie gebied.
My lady, I can't agree with that because all militaries right across the world have got an intelligence component that will gather information relative to their area, or so as the people within that area, relative to the countries in which they are operating.
Well, I put it to you, Mr. van der Westhuizen, that you're being evasive because there is evidence before this court, for example, Operation Katzen, which engaged in deceptive activities as described.
Meneer van Westhuizen, ek wil dit aan u stel, dat u die vraag ontdek, want daar is organisasies soos die organisasie Katzen wat dan met hierdie bedrieglike aktiwiteite voortgegaan het.
Die edele nee, ek het nou net bevestig dat hulle wel in operasie Katzen pamflette gedruk en versprei het.
My lady, no. I just confirm that in Operation Katzen that they did print out pamphlets and distributed same.
Were you aware of tension between two organizations, ZAPA and UDF?
Was u bewus van 'n spanning wat geheers het teen twee organisasies, ZAPA en UDF?
Ek is nie nou te lewe was aan die van nie, maar ek kan my herinner dat daar onderlinge striweling was tussen organisasies.
I can't recall clearly, my lady, but what I can recall is that there were some issues, struggles between the organizations.
And there are allegations that in fact it was military intelligence and the security branch that was encouraging that conflict between those two organizations.
En daar is ook inligting dat dit die militaire intelligensie, de samenwerking met die veiligheidsmag wat bygedra het tot daardie spanning tussen die organisasies.
Die enige ek beskik nie oor daai inligting nie. As dit so was, dan aanvaar ek dit.
My lady, I don't have such information, but if it was the case, then I accept it, my lady.
Now, following the murders of the Cradock Four, are you aware that a cover story was put out that the murders were the result of fighting between ZAPA and UDF?
Is u bewus met betrekking die dood van die Cradock 4 was daar opgemaakte storie dat dit as gevolg van die striweling onder ons is tussen die verskillende organisasies.
Ek kan nie nou antwoord dat ek die klokkie by daardie oortjie gebring het hierdie edele.
I can't answer to what is being raised as far as this is concerned, my lady.
Let's turn to the workings of the Joint Management Committee, the JMC in Port Elizabeth. Am I right in saying that that was quite a
notification?
I'm going to repeat that because there was some interference.
Yes, though.
I want to turn now to the Joint Management Committee and how it worked in Port Elizabeth. Am I right in saying that it met approximately once a month?
Meneer, ek wil nou gaan na die gesamentlike bestuurskomitee hier in Port Elizabeth. Is dit korrek sodat dit eenmaal per maand vergader het?
Ja, dit is korrek. Ek dink daar was ad hoc vergaderings ook gewees.
Yes, my lady, that is correct. I think there were also ad hoc meetings that were held.
Yes.
Yeah.
And as I understand it, there were numerous heads of local and provincial government departments represented on this committee.
Ja, soos ek verstaan was daar verskillende departments hoofde, was dit op provinsie vlak en ook plaaslik wat op daardie kommissie deel was van sodanige vergaderings.
Ja, dit is korrek. Elke departement moes 'n verteenwoordiger op die GBS hê. Al die departemente het adjunkt verteenwoordigers ook aangestel.
My lady, that is correct. All departments had to have a representative at the GMC appointed by them.
And just as a matter...
Wil net sien klaar. Kan ek byvoeg hier?
Can I add?
Yes, go ahead.
Ja, ek kan voortgaan om by te voeg, generaal.
Ook die lede van die plaaslike regerings, die stadsrade of die munisipaliteite het verteenwoordiging gehad en daar was 'n adviesraad van die UPE, Universiteit van Port Elizabeth, wat ook sitting gehad het.
Also, the local governments had also a sitting on the committee, like the city manager, as well as the divisional council, which is the state council. They also had a sitting, and there was also an advisory commission that was also part of this structure.
And did the chief magistrate ever sit on the JMC?
En die hoofmagistraat ook gesit daar op die GBS.
Nee, Edele.
No, my lady.
Because, apparently, in the beginning, the chief magistrate did attend some meetings, but he was stopped from coming because of a fear of compromising the courts.
Daar is inligting dat op 'n sekere stadium het die hooflandros gekom om die vergaderings by te woon. Hy was stopgesit want daar was 'n vrees dat hy sy posisie sou kompromiseer.
Dit kon voor my tyd gewees het of selfs daarna. Ek dra nie kennis dat 'n magistraat enige GBS-vergadering bygewoon het nie.
That could have been before my time or after my time, but I don't bear any knowledge about a magistrate who attended the meetings of the GMC, my lady.
And am I correct in saying that there were 3 subcommittees known as FACOM, Security Subcommittee, COMCOM, Communications Subcommittee, and the JIC, the Joint Intelligence Center?
As it was correct, daar was hier 3 committees, FACOM,
COMCOM, Communications, and,
COMCOM, Communications,
and Joint Intelligence Center.
en gesamentlike intelligensie sentrum.
Edele, gedeeltelik ja, daar was komponente gewees, afdelings gewees van die GBS wat standaard landwyd was. Ek sal hulle nou vir u opnoem.
Partly, yes, my lady. There were some components of the GMC that were in place and which I'm going to set out now for the court.
Just try that again.
Kan u weer praat, generaal?
Die eerste komponent was die veiligheidsafdeling.
Now, the first component, well, from the various divisions was the security division.
Die veiligheidskomponent het 2 subkomponente gehad, namelijk de operatiekamer en de tweedens een inlichtingscentrum.
Now, the security component had 2 components. The one was the information component, and what was the last, generaal? The tweede een?
Die inlichtingsafdeling.
That was the information division.
Die tweede hoofdkomponent was staatkundig.
The second component was relative to the state.
En by daardie komponent, die staatkundige komponent, alle departemente of instansies wat 'n belang gehad het by staatkunde, die regeringskunde van die hele commandement gesit.
Now, in that particular component, there are various people that participated from the states component, from the government component, and all of the other components who had an interest of serving in that component.
Thank you, Mr. Van der Westhuizen. We're going to have to move on because time is not with us. Am I right in saying that there was an executive committee, Dagbestuur committee, that you chaired and which met on a frequent basis?
Is dat correct, so meneer, dat daar bestuurskomitee, namelijk die dagbestuur wat u als voorzitter opgetreed wat gereeld vergader het?
And it consisted of the 3 chairmen of those subcommittees.
En dit is ontstaan deur die 3 voorsitter van daardie subkomitee.
And during 1985 it met almost daily.
En in 1985 het hulle amper dageliks by mekaar gekom.
Daar was 'n dagbestuur wat ek ook die voorsitter was.
There was
Ons het nie elke dag ons het nie daagliks by mekaar gekom nie. Ons het op 'n vooraf gespreekte wyse die volgende vergadering bespreek.
There was an executive committee presided by myself, but we were not meeting daily, but you will meet as we scheduled meet the next meeting. Then you will meet in that fashion.
And am I right in saying that the most important decisions were taken in those executive meetings?
As ek reg as ek sê dat die mees belangrike besluite was in daardie dagbestuur vergadering geneem.
Ek kan daarmee akkoord gaan, die mees belangrike besluite wat dat die dagbestuur saam besluit maak nie.
I can go in agreement with that because those people also had a contribution in making critical, important decisions.
And is it correct that the situation in Cradock, and in particular the role of Mr. Gqeberha, featured prominently in those discussions?
Is het correct so dat die Cradock aangeleentheid en veral die rol van meneer Gqeberha, dat het die hoofrol gespeel het in daardie besprekings?
Die edele dit mag geopper wees, ek kan dit net nie onthou nie.
My lady, it could have been raised, those meetings, but I just can't recall it, my lady.
And in terms of the relationship with the State Security Council and the Secretariat, am I correct in saying that decisions made in the JMC had to be carried out by the relevant departments, and that these decisions were minuted and sent up to the National State Security Council Secretariat?
Nou, is het correct so dat die staatsveiligheids maatskappy dat hulle inligting deurgevoer het na die ander komponent wat het verder gevat het vir besluite?
Die edele, ek wil weer beteken, die OPGBS of geen ander GBS het enige besluitnemingsregte gehad nie.
My lady, I do want to emphasize it again. There's no GMC that had the right to make decisions.
Hulle kon aanbevelings maak en voorstelle maak wat verteenwoordigend was van die GBS se besprekings of se gevoele op daai stadium.
They could make some recommendations and suggestions where the feelings of the GMC were expressed and also where they felt to inform what they were deliberating on.
Now, in 1985, Was there ever a decision to set up a civil cooperation bureau in Cradock?
In 1958 was daar ooit 'n besluit dat daar 'n siviele bureau in Cradock, veiligheidsbureau moet bevestig word in Cradock.
Not veiligheids.
Ja.
'n burgerlike samewerking eenheid.
Burgerlike samewerking eenheid.
Daar was nie op OPGWS of enige ander vlak daaroor besluit nie. So ver my kennis strek, was dit 'n besluit wat in Pretoria geneem is deur die hoofkwartier in Pretoria. Ek dra nie kennis verder nie.
My lady, according to my knowledge, the GMC couldn't make such a decision, and it could not be made elsewhere, but such a decision was made at the headquarters in Pretoria. Hence, I don't bear any knowledge about such a decision made elsewhere, except for the headquarters.
And do you recall if such a unit was in fact established in Cradock?
Kan jy onthou dat sodanige eenheid wel in Cradock in die lewe geroep was?
Die edele, ek verstaan dat die gepraat word van die BSB. Ek kan die term onthou, maar dit was nie 'n kommandementsaangeleentheid nie. Hulle was nie onder my bevel nie.
My lady, I understand what is being talked about here. Kan nie weer kom, ek het nie geskrewe goed vir my nie. Die organisasie se naam, generaal? BS?
Excuse?
BS.
Burgerlike Samewerkingsbureau.
I'm with you. That citizen cooperation movement was established in Cradock. Do you agree? Can you recall that such an organization was established in Cradock?
Ek is nie bewus daarvan, u edele.
I don't bear any knowledge about that, my lady.
As I understood your answer, Mr. van der Westhuizen, you indicated that that particular organization, the Civil Cooperation Bureau, was set up and controlled from head office in Pretoria, and that you were not involved in it.
As ek reg verstaan dat hierdie organisasie se gesamentlike bureau, dat dit in Pretoria was en dat u die deel daarvan was nie.
Ja, dit maak nie vir my sin, want Johan van der Westhuizen, as ons van die regte persoon praat, was 'n lektor by die Universiteit Port Elizabeth.
Maar I understand correctly. Johan van der Westhuizen was a lecturer at the university in Port Elizabeth.
All right, I'm sorry to interrupt you, Mr. van der Westhuizen. We have to move on. Can I ask, you mentioned yesterday that various politicians from time to time came to Port Elizabeth, such as Magnus Malan. Were you ever under pressure from those politicians to stabilize the Eastern Cape region?
Gister het u melding gemaak dat verskeie politieke figure die vergaderings kom besoek, was soos Magnus Malan, was hy enigszins onder druk om die situasie in die Oos-Kaap onder beheer te bring of te neutraliseer.
Ja, ek kan 'n besoek van generaal Malan onthou. Daar was waarskynlik ander politieke leiers ook, en ek was wel onder druk gewees.
Yes, my lady, I do. I'm aware about the visit of Mr. Magnus Malan and other political figures, and I was very much under pressure.
Can you explain the nature of the pressure?
Kan ek die aard van die druk bespreek?
Die druk wat hulle uitgeoefen het, was dat die OPGWS moet beter funksioneer, weer effektiewer funksioneer as wat hy op daai stadium gefunksioneer het.
The pressure which they exerted was that the GMC must function better than it was functioning then, my lady.
And am I right in saying that Magnus Malan even went so far as to say that unless you brought the Eastern Province under control, you would be replaced, you would be fired?
En is het correct so dat meneer Magnus Malan gesê het, tensy u nie die Oos-Kaap onder beheer bring, dan sal u vervang word en u sal afgedank word?
Dit is nie korrek nie, ek het dit ook nie so verstaan nie, en hy het nie direk vir my so gesê nie.
That is not correct, my lady, and I didn't understand it as such, and that was not conveyed directly to me, my lady.
Now, I want to turn to your evidence before the Zitzman Commission.
Ek wil nou gaan na die getuienis voor die Zitzman Commissie.
Now, I'm not going to trawl through 500 pages of testimony. We simply don't have time for that.
Ek gaan nou nie deur die hele 500 bladsye getuienis nie, want ons het die tyd daarvoor nie.
But I do want to engage with you on your statement that you made to the Commission dated the 10th of May 1992.
Ek wil net u met u beraadslag oor die verklaring wat jy op die 10de Mei gemaak het in 1982 wat ek met u hanteer.
My lady, this can
Before
be...
you continue, can I just establish, Mr. Van Zyl, whether you now have the view of the court?
Meneer
Yes, we do have. Yes, my lady, thank you, we do.
Alrighty. Yes, Mr. Valley.
I'm grateful for your intervention, my lady. My lady, this particular statement can be seen at volume B2 at page 4930.
Yes.
Mr. van der Westhuizen, I'm going to be focusing on just a few paragraphs, particularly between paragraphs 15 to 22.
Meneer van der Westhuizen, ek gaan net konsentreer op 'n paar paragrafe, paragraaf 15 tot paragraaf 22.
And let's start with paragraph 15, where you talk about the infamous signal of 7th June 1985.
Kom ons begin met paragraaf 7 waar u praat van die ongewilde sein van die 7de Junie 1985. 1985.
And I quote, "As for the signal itself, I must state that it is not in my handwriting, nor did I sign it.
Maar ek net sê die sein is nie in my hand nie en ek het dit nie onderteken nie.
I cannot recall the signal if it ever existed.
Ek kan nie onthou of die sein ooit bestaan het nie.
Do you stand by that evidence in your statement?"
Volstaan u by daardie getuienis in u verklaring?
Die edele, ek het nie die sein behoort nie, ek het nie die sein geteken nie, ek het nie die sein gestuur nie.
My lady, I did not compose the signal. I didn't look at it, and I did not forward it. I didn't send it.
And your claim back in 1992 that you could not recall the signal if it ever existed.
In 1992 het u gesê dat u nie kennis gedra het of die sein ooit ontstaan het nie.
Ek kan dit aanvaar, dit is 7 jaar later dan, ek kan nie onthou eers dat ek 'n sein gestuur het nie.
That is
Ek
correct.
het in elk geval nooit sein gestuur nie.
That is correct. So it was 7 years later, and I could not recall whether I did send such a signal. In fact, I never sent such a signal, my lady.
Well, we're going to get onto that, but I must put it to you that we will put it in argument that that statement, that you cannot recall the signal, if it ever existed, was a manifestly false statement on your part.
Nou, ons gaan betoog daar die verklaring wat u sê dat u nie bewus was van die ontstaan van die sê nie, dat dit 'n valse verklaring was.
Ja, ek het baie gaan daaroor tyd.
Yes, I accept that there will be evidence relating to that.
And then turning to paragraph 16.
So ons gaan na paragraaf 16.
I'm translating. Regarding the contents of the signal, I also cannot recall the telephone conversation with General van Rensburg mentioned therein, nor the reasons why any names would have been supplied to him.
Nou betrekking die sy en ook die inhoud daarvan kan ek nie onthou of die naam van generaal van Sail daarin genoem was of ook sekere name nie.
Do you stand by that statement?
Yes.
Ja, die sy soos hy daar staan is korrek.
Yes, my
Die inhoud van die paragraaf is korrek.
The saying as it stands there is correct, and the contents as they are reflected there are correct.
And you persist with that version today?
En if volstaan by daardie weergawe vandag.
Ja, edele.
Yes, my lady.
I put it to you, Mr. van der Westhuizen, that you are giving false evidence before this court.
Ek stel dit aan u, meneer van der Westhuizen, dat u valse getuienis voor hierdie of aflê.
Kan u vir my verduidelik wat is vals aan wat ek gesê het?
Can you explain to me what is false in what I said?
Your claim that you could not recall having a telephone conversation with General van Rensburg before the signal was sent, nor the reasons why any names would have been supplied to him.
En die feit dat u geen 'n telefoongesprek gehad met generaal van Rensburg en ook dat daar geen naam deurgevoer was.
Perhaps you can continue to inform the witness why you put it to him. Yeah, that is the case, Mr. Bani.
Miskien kan u die getuie aanlig. Hoekom u so stelling maak aan hom?
Well, I put it to you that it is false evidence because it is so utterly improbable that you would forget a conversation that prompted the sending of a signal that called for the permanent removal of 3 individuals.
Meneer, ek stel dat u dat het hoogst onwaarschijnlijk is dat u nie sodanige telefoongesprek gehad het, nie met betrekking name, en dat 3 persone permanent uit die samenleving moes verwyder word.
Ek kan nie onthou wat generaal van Rensburg vir my gesê het of wat ek vir hom gesê het.
My lady,
Dit
ek gaan my aan generaal.
Dit kom nie eers in my geheue, selfs nadat ek agterna gehoor het van die inhoud van die sein nie. Of dat ek het agterna gesien het.
My lady, I can't recall what I said to General van Rensburg or what he said to me, and I can't recall it when it was even sent.
Let's move on to paragraph 18.
Kom ons gaan aan na paragraaf 18.
In this,
Lady, I want to object at this stage to this line of cross-examination. I've indicated earlier to your ladyship that there is no purpose at this stage to confront this witness now with something that an affidavit or a statement that he made 30 years ago, and to merely put into him that it's going to be argued that it's false. If Mr. Barney wants to argue that the contents of the statement is false, then so be it, he can do it. It is unfair to confront this witness now with something that he recorded, or the statement that he recorded 30 years ago with what he remembered at that stage when he made the statement. I've already also indicated to your ladyship on 2 occasions, and I'll do it now for the last time, that the contents of the signal was considered by Zitzman JP. He made his findings, and the witness indicated also in his statement that he submitted to your ladyship that he abides by those decisions and findings. What the meaning of the signal was, the contents thereof, and what was to be conveyed as found by Zitzman J. And any further cross-examination of this nature won't take that issue any further, other than to put to the witness, after he's been referred to the contents of paragraphs, that it is a lie. If Mr. Varney wants to argue that at the end of the day, he's welcome to do so. To put it to the witness every time, he's not going to make that argument in his strong.
If the argument is to be put forward,
So and it is an exchange
and to the put up a version in crucial.
of the
Can be
only the time not to issue the issue. Statement years ago is now recorded and then or not. It's not the senior lady that you have to. Understand that
just in the
that wouldn't do. the signal.
As het correct is, paragraaf 8 voor zijn comité dat die staat
and indeed on paragraph the General Fund
verkend was die Gqeberha, generaal van Rensburg.
Lady, just too short. The interpreter to
Thank you.
Words for a period.
Not, but that of the security police, my lady.
Evidence in 92, the word permanently removed from society could only mean that person detained. That was
Die NE verklaring weet wat die mense manier dan daarop op dat hulle in by waar die verklaring of die woorde.
Ja, dat was op de OPCBS vergadering geweest, waar voorstellen
there was a meeting in the GMC that this people, they should never be hired, never ever again.
Yeah, we're going to.
En dus, daarop ons uit die
from society.
To focus on the question, Mr. Westhuizen, the question was the word permanently removed from. Does it mean to be detained for a long period?
Now,
I would with line of question. The issue that with days on end as this was crossed in detail of this granting him testify years ago. If you not with an objective that this is not the meaning of the has been made by if you overrule my not overrule, then you do not want to make a rule that I request to do my full argument.
So, what is the objection?
This is an issue that was and testified during proceedings before JP. The meaning of the signal, that the telephone call between Rensburg and the witness, what was conveyed by the signal, this witness was confronting with that he gave 30 disposal is unnecessary. It's wasting, not going to you at making a finding that this witness ever in the ladyship is of the view with
take a seat.
Can I ask, are you going to commit to present full argument
yes.
on this question?
Yes.
Well, Milady, can I just raise an objection that this is an abuse of court? He is raising absolute arguments.
Yes, that's why I want to hear him. Objection. I still haven't gotten the gist of the objection, so I need to hear his argument.
Yes, my only concern is that we're now going to spend 30, 40 minutes
yes.
on this.
And unfortunately, I must get the gist of the objection or the nature of the objection, which I haven't gotten up to now.
Well, Milady, I must raise my concern and objection at this waste of time, because it's such a radical departure from accepted and due process in inquest, as the court pleases.
What is not acceptable? To raise an objection?
Well, Milady, he's raised the objection. You have made a ruling on the matter, and we would submit the correct ruling. And now to permit my learned friend to spend 30, 40 minutes arguing the matter and raising quaint pieces of law that are baseless is a waste of this court's time.
I need to hear his argument, unfortunately, Mr. Devan.
As the court pleases.
Yes,
Thank
Mr.
you. Lady, for the opportunity. My lady, may I just inquire, do you have my heads of argument at your disposal? It was circulated.
I don't have a hard copy. It should be, there must be a copy somewhere, but I don't have one now. But you can continue and address the court. I'll try and have it arrange for it to be printed for me.
My attorney indicates, Mr. Fisher, that he did hand you up a hard copy on, I think, Tuesday.
You can carry on, Mr. Fonseca.
Thank you, my lady. My lady, the background to this inquest, you are well aware of that there was an inquest in 1989 before Mr. De Beer, this gentleman from the Westhuizen. I may just mention, whilst I'm doing my argument, that he just be briefly excused just to take a walk. So if it's in order with your ladyship, that I proceed in the meantime.
Yes, if you want to proceed in the absence of your client, you may proceed. I don't have a problem with him taking a walk.
Thank you. The lady, he did not testify before Mr. De Beer, but then we all know that in May 1992, that was when the article appeared in the New Nations newspaper containing a photo of the signal, and then subsequent to that it was decided then that the inquest presided by De Beer should be reopened, and Zietsman JP was then requested by the then Minister of Justice to preside over the reopened inquest. In his finding,
Lady, I don't wish to unduly
interrupt. Just a moment, Mr. Fonseca. Mr. Vani.
Lady, I don't wish to unduly interrupt my learned friend, but I do have his heads of argument here, and he's reading it word for word. It's 26 pages long. Milady asked for a summary of the argument, not for him to read out the entire argument.
No, I asked him to make the argument, Mr. Vani.
Yes, Milady, but are you going to permit him just to read out 26 pages as opposed to giving a summary?
Yes, Mr. Van Zyl, if you can give us the silent features of your, or the silent parts of your argument.
Firstly,
I now
Mr.
have
Barney should know that.
I now have a copy of your heads of argument.
Yeah. Just firstly, Malaine, Mr. Barney should know that I'm entitled to act in the best interest of my client. I have, during these proceedings, on numerous occasions heard that whenever an objection is raised, it's an abuse of process, it's baseless, etc., etc. This is not a contest between myself and Mr. Barney. The basis of my objection is in order to serve the best interest of my client, and I would like him to, in future, not persist with these type of allegations and arguments that he raises that we are wasting time and abusing the process. That is not what I'm doing.
Thank you. You may proceed.
We would also have seen
yes, proceed, but please, Mr. Van Zyl, please, but don't read line by line and word for head from your head.
I did not do it. I'm already on page 3 of my heads of argument.
Yes,
so if Mr. Barney follows my heads of argument, you will see that. I'm on paragraph 3.2. Finding of Zietsman with regards to the reason for the reopening of the previous inquest was the following. It was then decided that the inquest into their deaths should be reopened, and I was suggested by the Minister of Justice to preside. Now, the reason was the signal. There was no other reason why that inquest before Zietsman JP was opened. I mentioned that in paragraph 3.3. So that was undeniable that the trigger event of the reopening of the inquest was the publication of the signal. Lady, if we then turn to paragraph 4.1, I just make the submission there that there was extensive examination and cross-examination of all the witnesses, including this witness. Paragraph 4.2, those are the issues that are listed also in his statement that he submitted to your ladyship, of which he testified, or on which he testified. Paragraph 4.3.2, I refer to the signal dated the 7th of June sent by the PC with specific reference to the interpretation of the wording of the signal and the circumstances surrounding the sending thereof. Therefore, I'm not afraid to put in hundreds of pages of cross-examination on this issue, not only of this witness, but also of Colonel Du Plessis, as well as Major General van Rensburg, who was at the Secretariat. That was, I can guess, at least 80 to 90% of all the examination and cross-examination concerned that signal. Lady, then paragraph 5 on page 6, what Zietsman JP also recorded, exhaustive investigations were done, and then further on, and then in the fourth line, the South African Army, the South African Police, and the Department of National Intelligence were represented by counsel, as were the families of the deceased persons. So the families were duly represented during those proceedings by Mr. Bezos and his junior, if I can call correctly, he's a now retired SCA Judge Nofsal. Then in the next paragraph, he reported, I'm greatly indebted to the various counsel involved for their thorough examination and cross-examination of the witnesses called to testify, and for their considerable assistance in the matter. That just gives impetus to the submission, my lady, that this witness has been extensively examined 30 years ago on this exact issues that Mr. Barney is now attempting to cross-examine him again. Paragraph 6, it's also mentioned that he, at that time also, at that inquest, he submitted 2 statements to the court. Paragraph 7, on page 7, my lady, that's just the findings that he made, that Zietsman made. It's not that important to go through that. Paragraph 8.1 is the important paragraph. The finding of Zietsman included positive findings with regards to the identity, causes of death, and date of the deaths of the Cradock 4 based on the facts before Zietsman at the time. Then those Zietsman indicated that there is suspicion. Well, I don't need to read that. 8.2, it is submitted that this Honourable Court is bound by the findings of Zietsman unless there is new, credible, admissible, and available evidence that could lead to a different finding in this regard. I'll come back to this issue a bit later in my age. Lady, that tags along with that findings of his was were the findings that I already referred to with regards to the meaning of the signal and the wording thereof, etc., etc., of made those submissions. In paragraph 10, Zietsman considered the evidence of the applicant, the Principe van Rensburg, Brigadier Geldenhuys, Mr. Stemmet, and Mrs. Foster. All of them gave evidence in relation to the signal. And then in paragraph 11, my lady, that is the finding that I've earlier referred to. It is, however, and I read from the quotation, it has, however, in my opinion, been prima facie established on the evidence as a whole that the meaning Colonel du Plessis intended words used by him in the signal to have is that Matthew Gqeberha, Lewe Gqeberha, and Fort Kalata should be killed. And that's kind of question, my lady. That's the end of that inquiry. He's made that finding, and my client already indicated that he abides by that finding. Zietsman then further considered whether to proceed as paragraph 12 correctly understood the instruction to him. And then he said, he found in that regard, in my opinion, it has been established that the signal was intended by Colonel du Plessis to mean that Matthew Gqeberha and the others should be killed, and also that this is the meaning that Brigadier van der Westhuizen intended should be conveyed in the signal. I do not understand what other finding Mr. Barney or any other person representing the families want you to make in that regard. You cannot make a more adverse finding, and it's only a prima facie finding that was the meaning of the signal. Unless they wanted to make a less adverse finding, I do not understand why we have to go through this exercise of cross-examination of this witness on exactly the same issues for days on end. I don't know if it's to embarrass him, but it will not take it any further. Lady, if I then just go to page 11, paragraph 17, that is the current proceedings, my lady. The paragraph 17, I just referred to what the basis of this inquiry, or the opening is. We requested documents from the NDPP that were submitted to the minister in order to have this inquest reopened. We have not received that. They did not give it to us. We requested it on numerous occasions. As we understand, and I'll quickly refer there to my lady, that the purpose of the reopening of an inquest is when there is new evidence that justifies the reopening, and that the witness can then be called to give further evidence based on that new evidence that led to the reopening. We don't know if the basis of the request for the reopening entailed that there is new evidence, that the minister was referred to possible new evidence. The only new evidence, as far as we are concerned, that have been obtained in the meantime is the evidence of the 6 persons who applied for amnesty, the 6 security branch policemen who applied for amnesty before the TRC, where they admitted that they committed these crimes. Lady, we also put on record in this proceedings when we commenced, my lady, and referred to that in paragraph 19, that you are required to make a finding only in this regard, in the last mention regard, my lady, as to whether the deaths were brought about by an act or omission prima facie involving or amounting to an offence on the part of any person or persons. That is the only issue that needs to be decided. Mr. Barney then, in his opening address, I was referring now to paragraph 21, page 14 of our heads, in his opening address, the current proceedings at Gqeberha stated the following. Now, notwithstanding that all the masterminds and killers who applied for amnesty were denied amnesty, all the masterminds and the killers from the post-apartheid authorities took no steps against it. That was his opening statement, that the persons who planned and killed the deceased applied for amnesty, and nothing was done in terms of prosecution after they were denied amnesty. Paragraph 23 of page 15.
Mr. Van
my lady.
Sorry, Mr. Van Zyl, don't you reckon that the questions being raised at this point with the witness will have a bearing on that question, on the finding that the court has to make? In particular, as to the persons or the identity of the persons who were responsible for the planning and the execution of the murders?
Lady, no, not at all. And in any event, this has been, all these issues have been traversed at length before Zietsman J. The purpose of a reopening of an inquest is not to get a second bite at the cherry. It's not there to recall a witness and cross-examine him at length again about the same issues that were previously traversed in a previous inquest. There's no basis, on all due respect to your ladyship, that you can allow that. This is not a review of previous proceedings. This is not an appeal of previous proceedings. This is not a reopening from the start of the previous proceedings. And I'll refer you to case law in that regard. The witness already testified about this issue. He denies it. The evidence that is being referred to now by Mr. Varney, which Mr. Varney argues that he will argue is false, that evidence was before Zietsman J. On what conceivable basis can they ask you now on the same evidence to come to a different conclusion? You can, with respect, not do that. And that was evidence before Mr. Zietsman. Exactly the same evidence. So it's not for you, with all due respect, my lady, to come now to a different conclusion based on exactly the same evidence. But I will now briefly refer you to case law in that regard. Then I refer to the TRC findings, that the finding of the TRC on page 16, paragraph 25, was specifically that the policemen that committed these crimes would have done so irrespective of any order that they were given or not. And that's on page 17, the top part, my lady. The second line, the existence of the alleged order they rely on is effectively excluded by their own decision to kill the 4 deceased, including the Niwi, in any event. So the reliance on and respect for orders on the one hand and the decision to kill the other hand is self-destructive. So the finding of the TRC was that the policeman that did the killing did so they were actually on a frolic of their own, whether they received an order or not, they would have done so. And that is evidence that is now before your ladyship, not something that we grab from the sky, that is part of the papers before you. Lady, the evidence at the TRC, I refer to that on page 18, my lady. In summary, what I will submit in that regard is that all the policemen that were questioned in that regard during the amnesty application denied any knowledge of the signal. They were asked about that, and they said they did not know about the signal, at least not prior to the killings. Colonel Snyman said that he now currently, when he made his application, has knowledge of the signal. But prior to that, he did not have any knowledge. And that was the evidence, and refer in the record, all of them from Tail, von Rensburg, and also Taylor, and see as well as Snyman. We've looked at his evidence yesterday. I had a look at it again at that, and I confirmed that he also stated that he had no knowledge of the signal prior to the killings. And in any event, the PRC found that they would have committed these crimes in any event. Then the provisions of the Act, important, my lady, paragraph 35 on page 21. Section 17A of the Act provides that the Minister may, on the recommendation of the Attorney General concerned, request the reopening of an inquest, and such inquest shall be continued and disposed of as provided for in subsection 17A to 23, which provide as follows, and I quote, as far as possible be continued and disposed of by the judge so designated on the existing record of the proceedings. The provisions of section 17 sub 2 shall, insofar as they are not contrary to the provisions of this section, apply mutatis mutandis to such an inquest. 3, and this is important, my lady, a judge holding an inquest that has been reopened in terms of this section may cause any person who has already given evidence at the inquest be subpoenaed to give further evidence. So I record any finding that differs from a finding referred to in section 16.2, as well as that in respect of in which he differs. And then 35.2 of importance in this context is the provisions of section 12 sub 2 of the Act provide as follows. An inquest commenced by a judicial officer who through absence, death or incapacity becomes unable to continue such inquest may, subject to the provisions of subsections of section 6, be continued by any other judicial officer as if the inquest had been commenced by such other judicial officer who may cause any person evidence as if he had not before so given evidence. So there is a distinction between the two different scenarios. In the case of a reopened inquest, my lady, a witness who has already given even evidence at the inquest may be subpoenaed to give further evidence, and in the event of a judicial officer becoming unavailable and there's a new judicial officer appointed, then of course the person can be subpoenaed to give evidence as if he or she has never done given evidence before. Paragraph 37, I again refer to the situation that we have not been provided with documentation that culminated in the reopening of this inquest that had to be submitted to the Minister. Lady, then we refer on page 24, paragraph 38, to the decision of Inrai Mjoli, lady, where the question of further evidence was discussed, and I refer then to page 344 of the decision. Volgens Hiemstra en Groningen rechtswoordeboek beteken verder bykomend, aanvullend, nader, noukeuriger en fynere besonderhede. Selfde oordraaglike betekenis vind 'n mens in die Shorter Oxford English Dictionary. The Engelse word further, namelijk further means more extended, going beyond, additional, to a greater extent, more, going beyond what has been dealt with. The last lines of that quotation, my lady, purpose of such an inquiry can only be to obtain further information of such a person. Die doel van so 'n ondervraging kan alleen wees om verdere inligting van so 'n persoon te bekom of om die beweringe as 'n verklaring aan te vul. So what we have in this instance, my lady, we have a witness that's been that gave testimony 30 years ago for days on end about this same issue. All the questions that Mr. Barney is now asking of him had been put to him. He was dealt with, even his answers. The record speaks for itself. Lady, then Mr. Altman yesterday also referred to Gail as a copy of the decision in the reopened inquest into the death of Ahmed Esop Timol. I do not have a case number, was IQ01/2017. I don't know if this, I know there's a Timol decision that was reported, but I don't think it's the same one. But in any event, that was the first time that an inquest was reopened, and a lady, I will request Mr. Colton maybe to, if he has it at his possession there, to give you a copy of this decision. Otherwise, we'll send it through to you. Paragraph 4, with the assistance of the Human Rights Foundation, eminent legal counsel, the Timol's nephew obtained further evidence relating to the death of Timol, which enabled them to approach the National Director of Public Prosecutions with information that was not placed or considered by the magistrate conducting the inquest in 1972. NDPP made a recommendation to the Minister of Justice and Correctional Services for the reopening, and that was based on further and new evidence that was not placed before the person or the magistrate that did the first inquest inquiry. I think in terms of the section, the Minister then decided that the inquest be reopened. The reopening of this inquest, well, I said it's the first time, I don't need to read that in paragraph 6. Later, then, if I can turn to paragraph 5 of that, 5, paragraph 13, references to the other Timol decision that was reported, that is the purpose of an inquest is dealt with then, and then on that on page paragraph 7 of that decision, the following is Section 70, capital A1, that is the section that deals with into the original text as an amendment by Section 1 of Act 142, provides that the Minister may, on the recommendation of the Attorney General concerned, at the time after the determination of an inquest, if he deems it necessary in the interest of justice, request the Judge President of the Provision of the Supreme Court of South Africa to reopen that inquest, whereupon the Judge thus designated shall reopen such inquest. Then it also deals with the distinction between Section 17.2 and Section 17 capital A that I also referred to in my heads of argument. And in this decision, the following was stated. The Act draws a subtle distinction between the reopening of an inquest in terms of Section 17.2, that is when the judicial officer becomes unavailable, and in terms of Section 17A, that is under these circumstances. Under Section 17 sub 2 and 3, an inquest is reopened at the request of the Attorney General, directed to the judicial officer who presided over an inquest, to take further evidence generally or in respect of a particular matter. In practice, it would ordinarily be before a regional magistrate or magistrate who made the finding. The process is designed to focus on taking further evidence following an initial finding of the inquest. In paragraph 20, in regard to Section 17, capital A, the Director of Prosecutions makes a request to the Minister for the reopening of the initial inquest by a designated judge, who is also empowered mutandis to take further evidence generally or in respect of a specific matter as in Section 17.2. Thus, Section 17 capital A of the Act empowers the judge presiding to exercise the provisions of Section 17 sub 2 to take further evidence generally in or in respect of any matter in effect of the purposes of the reconsideration of the entire evidence, including on the existing record. Most importantly, 17A3, I do not read that. I need to read that paragraph, my lady. I'm going to refer to the last paragraph in that decision. So, page 927, which in my view is very important. Finally, the reopened inquest is neither an appeal nor a review of the initial inquest. In both these instances, a court is confined to the record of the inquest. The entire evidence considered by the initial inquest at the time. What other reason was or cannot be considered the initial inquest proceedings and has become available. This is the information that would justify a reopening. And the lady, as I've indicated, from our point of view, and before during the case management meeting, that we be provided with the documentation that the other legals consider to be new evidence, so that we can prepare on that. The only new evidence that we have as far as we consider or concerned was not all of it, and then of course the amnesty applications of the policemen that admitted that they committed these murders before the TRC. So maybe just in summary, the argument is firstly that the witness should not now be confronted with issues that were properly dealt with and evidence that was available before J and was properly dealt with by during cross-examination. There is nothing new with what Mr. Varney is now referring to. It's not new evidence. It's a statement that was already submitted to J in 1992, 1993. It's unfair to now confront the witness again with his evidence that he gave 30 years ago that was properly considered by J. The finding has been made with regards to the convictions. The witness already indicated that he abides with those findings, and it's unfair at this stage, we submit, to now again confronting with those issues that were traversed, evidence that was available and was considered by the judge and was used in cross-examination by Mr. Bezos and other advocates, my lady, and we submit that at this point in time, further cross-examination on this issue should not be allowed any further. It will not assist you at all in coming to a conclusion of who were the persons that murdered the Cradock 4. You have the admissions in any event of the policeman that said they did so. So we, on that basis, request you, my lady, to make a ruling that no further cross-examination will be allowed on evidence given previously by this witness, or to confront him with statements that he made 30 years ago, and then just put it to him eventually that it's a lie, and that Mr. Varney will, at the end of the day, argue that it's not the truth, which he is more than welcome to do and can do without having to go through this process of cross-examination as a court.
Thank you, Mr. Fonse. Mr. Varney.
Lady, after being involved in multiple reopened inquests in recent years, I just have to say that is one of the most astonishing arguments I've ever heard. My lady, my learned friend is simply about...
I'm not surprised.
My lady, I seek the court's intervention.
Sorry, I did not get that.
I just said I'm not surprised, my lady.
No, you don't have to interject when another party is addressing the court, please, Mr. Van Zyl.
My lady, that interjection is unethical, it's unprofessional, and I call on my learned friend to abide by the decorum and the rules of this court.
Yes, please proceed. I've already pointed that to him, please, to refrain from interjecting whilst you're addressing the court.
Yes. Well, frankly, my lady, the conduct we've just heard is consistent with the kind of argument he's put up. He is effectively asking this court to close down this inquiry. He's asking this court not to engage in a search for the truth. He's asking this court to prevent his client from answering questions that are germane, that are central to this inquiry. Effectively, he's saying, because a matter was canvassed in an earlier inquest, it's off the table. We simply cannot have any reference to it. Lady, I also want to highlight a paragraph from the judgment of Motley J in the Timol matter. Only one paragraph, and not even the entire paragraph. In paragraph 20, thus section 17A of the Act empowers the judge presiding to exercise the provisions of section 17.2 and to take further evidence generally or in respect of any matter in effect for the purposes of the reconsideration of the, and I emphasize, the entire evidence, including on the existing record. Most importantly, section 17A(3)(b) obligates the judge to record any finding that differs from a finding from the initial inquest. So, my lady, you are not bound by what Judge Ziesman concluded. You're not bound by his decisions in relation to credibility. You're not bound by his decisions in relation to findings on the fact. You are not bound by the finding he made. And so this ridiculous claim that we hear from my learned friend that somehow we're all bound by what Judge Ziesman says simply has no basis in law. This is a reopened inquest. My lady, he seems to take the view that if Judge Ziesman takes a view, you must take that view. That is just absolute nonsense. My lady, recently I've been involved in inquest, the Timol inquest, the Agate inquest, the Haffajee inquest, the Harun inquest, and there has been extensive canvassing of the earlier record with witnesses who testified previously, and not once was there an objection from a senior counsel representing persons of suspect in that matter. And of course, in those judgments, those courts dealt with that evidence and reached their own conclusions. And so, my lady, just in my learned friend quotes Majoli, even in that judgment, my lady, there's a reference to earlier statements that they can be seen in a new light and they can even be proven wrong. So, my lady, we would...
of the Majoli judgment states that?
Yes, my lady, it's at... it's actually in the paragraph quoted. So it's at page 344J to 345D. So, my lady, we would urge that no further time is wasted and that where questions are asked, for example, a basic question, there's a signal which is alleged to be a recommendation for murder, and there's a version from this witness that permanent removal means a lengthy detention, and then a friend doesn't want him to answer that question. My lady, I've never heard such absurdity before, and we would ask you to dismiss this application, if it can even be called one.
Thank you. Mr. Coltman, anything from the evidence leader's side?
My lady, I just wanted to confirm first what Mr. Van Zyl said. I did in fact circulate the Timol judgment yesterday morning to all the parties, and I also made a copy available to your ladyship. And in fact, all that we were going to do is to refer to those paragraphs that had been highlighted. And it's paragraph 20, middle of paragraph 20, and then paragraph 27, which encapsulates everything that Mr. Vani had submitted to your ladyship. So we support the argument made by Mr. Vani, my lady. Those are our submissions.
Thank you, Mr. Coltman. Any other party who wishes to make any submissions? Do we have Mr. Ngqeberha on the line? Do they want to make any submissions in this regard?
Good morning, my lady. Mr. Ngatobi has not yet joined us. However, we are covered by Mr. Varney. Safe to say that the ratio in Mjoli does not say what Mr. Van Sale says. In fact, it does permit this court to place earlier statements in a new light. I don't know if you can hear me.
Yes, I can. Ms. Buthelezi very clearly, loud and clear.
Thank you, thank you, my lady. And secondly, that Section 17A3 does not limit this court to only new evidence, and it cannot be interpreted that way. That's it from us. That's it, my lady. Those are my submissions.
Thank you, Ms. Buthelezi. Mr. Van Sale, anything you wish to say in reply? Mr. Van Sale?
Yes, my lady. Thank you, my lady. I might just mention that the passage that Mr. Barney referred to in the majority case is exactly the passage that I quoted in my heads of argument. So I do not understand with respect how it would be system. My lady, we've made our submissions. I'm not going to defeat that. I don't think there's really anything to answer. It's not a question that we want you to close down this inquest. It is, we've been participating in these proceedings for 3 weeks already, and we have indicated that the witness can be questioned on new issues or new evidence. We don't have any objection to that. He's been questioned for more than half a day already at this point in time. It's only as with regards to these specific issues that I've raised, and we submit that the further cross-examination should not be allowed as a court.
Thank you. Okay, shall we take the tea adjournment at this stage? Court will adjourn for 50 minutes.
As a court.
u dat u nog steeds onder eed is om die waarheid te praat? Bevestig u dit so?
Die edele, ja.
The witness has been reminded, my lady, that is still under oath to tell the truth. As it pleases the court, my lady.
Thank you. Before we adjourned, an objection was raised by Mr. Van Zyl, which basically amounts to the fact that it would be unfair to require the witness to answer questions he had answered during an extensive examination during the Zitzman inquest. Basically, that was the gist of the objection. That the purpose of this inquest is to hear further evidence. In the short periods that I have had during the tea adjournment, having considered the submissions made by the parties, I propose to give a ruling in the matter with a brief reason or brief reasons, and full and further reasons may be given at a later stage. The findings that were made in the previous inquests are well known to everybody. The provisions of the Inquest Act have been articulated by especially both parties who were involved in the objection, and the relevant portion of the Act is Section 17, capital A, that is the Inquest Act number 58 of 1959. The important part of that section, bearing in mind the findings that were made by, in particular, the Zitzman JP inquest, in my view, subsection 3B, that the court that is holding the reopened inquest shall record any finding that differs from a finding referred to in section 16, subsection 2, as well as in respect, or the respect in which it differs. In my view, therefore, the court, as is accepted, has regard or will have regard to what went on during the initial inquest, and that therefore it is open for the reopened inquest to revisit those aspects with a view of making a finding or indicating why it does not agree with the initial finding. That being the case, therefore, I will permit the questions to be asked in respect of the evidence already given by the witness during the Zitzman Commission.
Court please.
Yes, Mr. Van.
My lady, if we may then return to a question that I had posed, and I shall summarize it.
Ons gaan nou terug na die vraag wat ek gestel het, en ek gaan dit nou opsom.
Dankie, edele.
Thank you, my lady.
Mr. van der Westhuizen, you stated in your 1992 statement that the words permanently removed from society could only mean that the persons were to be detained for a long period. Do you persist with that view?
U sê in u verklaring van 1920 die woorde wat sê permanent verwyder uit die gemeenskap beteken eintlik om 'n persoon lang in aanhouding aan te hou. Volstaan u nog by dit?
Ek aanvaar dat dit die woorde is wat gespreek is. Ek kan dit sien in die bedoeling van die OPGBS se nooit ooit aanstelling weer van meneer Gqeberha nie.
I understand the words as they are being repeated and they were uttered by me, and that GMC wouldn't make any election or hiring of Gqeberha.
Mr. van der Westhuizen, I must ask you to answer the question. We simply want to know whether you, not the JMC, whether you meant that the words removed, permanently removed from society, meant a detention for a long period.
Meneer van der Westhuizen, bepaal u tot die vraag. De vraag is, die woorde wat sê verwyder, permanent verwyder uit die gemeenskap, dat dit sou beteken om 'n persoon vir 'n lang termyn in hegtenis te hou.
Ja, u edele.
Yes, my lady.
Well, I must put it to you, Mr. van der Westhuizen, that we will argue that you provided false evidence to the Zietsman Commission in that regard, and today you're providing false evidence again.
Nou, ons gaan betoog of argumenteer dat die getuienis in die Zietsman Commissie was vals, en ook die getuienis wat u in hierdie commissie, huidige commissie, aanbied, dat dit vals is.
U edele, dit is u reg om dit te kan doen.
Edele, that is your right to do that.
And you go on to say that neither I nor the EPJMC ever planned or approved the murder of any person.
Nou, u sê, nie u nie, nie ek nie, nie die GDSM nie, het enige besluit geneem vir die enige persoon wat gedood moet word nie.
And my question to you is, and I'm here again, I'm referring to you alone, I'm not referring to the EPJMC. As you stand here today, are you saying that you never planned or approved the murder of any person?
Except that he's seated, Ms. Stefan. Can proceed.
Nou, weer eens verwys ek na, ek praat na die GDMS nie, maar soos u daar sit, sê u steeds dat u nooit betrokke was by die beplanning van enige eense moord.
Dit is korrek, u edele.
That is correct, so my lady.
Well, in that regard, Mr. van der Westhuizen, we will be submitting that you are again not being truthful with this court.
Nou, in daardie verband sal ons aanvoer dat u weer eens nie in hierdie hof die waarheid praat nie.
U edele, u vra vir my wat ek onthou en wat my opinie is daaroor. Ek gee dit vir u, ek staan daarby.
My lady, you ask me what I'm able to recall, inviting an answer from me, what my opinion is, and I'm still abiding by that.
Then you state further in your affidavit, paragraph 22, that you cannot recall the interdicts referred to in paragraph 4A of the signal.
Dan sê u in paragraaf 4A van die sein kan u nie die interdikt daar verstaan nie.
Ek kan nog dit nou nie onthou nie, edele.
I can't even recall it myself, my lady.
Well, paragraph 4A reads, interdicts as recently with the disappearance of Godolozi, Hashe and Galela, in brackets PEPCO office bearers.
Nou is hy met die verdwyn van Galela, Godolozi, is die attitude,
Hashe and
en
Galela.
Hashe, en dit is die leiers van die PEPCO. PEPCO.
Ek herhaal, ek kan dit nie onthou nie.
My lady, I repeat, I can't recall that, my lady.
Well, we will be returning to that aspect, but I'll put it on record now that you are again not being truthful with this court.
Ons gaan weer terugkom na daardie aspek, maar ek plaas dit nou op record dat die weer eens nie die waarheid praat voor die hof nie.
Now, I want
Die enige, excuse, kan ek antwoord?
you may
Yes.
My lady, can I answer? Ja.
Die edele, dis 30 jaar terug. Hierdie gebeure het 40 jaar plaasvind. Ek kan nie onthou wat se interdikte teen wie daar was nie.
Edele, it is 30, my lady, it is 30 years back. And this incident occurred 40 years back, and I can't recall against whom there was an interdict as contained in the signal.
En kan ek byvoeg, edele,
And
die
can I add,
uitreiking van interdikte was nie in die domein van die weermag of die OPGBS nie, dit was 'n SAP besonder veiligheidspolisie aangeleentheid.
and once again, my lady, the issuing of interdicts were not within the domain of the GMC, but rather it was within the domain of the South African police, and it was not even within my domain.
I'm going to refer you to 2 paragraphs from the final report of the Truth and Reconciliation Commission dealing with Operation Katzen.
Ek gaan u verwys ook na 2 paragrawe van die oorkonde van die Waarheid en Versoeningskommissie.
And I'm going to quote the passages to you.
En dan gaan ek die paragrawe vir jou aanhaal. Thank you.
To seek your response.
En waar ek 'n reaksie of antwoord uitlok.
Lady, may I request Mr. Varney just to refer us to the pages so that we can get the documents before us, please?
Thank you. Yes, Mr. Vani.
Yes, I was about to do that. Milady, these documents were supplied in volume L4, and it is the TRC final report, volume 6, at page 243. And the paragraphs in question are 296 and 297. So I'm going to read the first paragraph. Planning documents submitted to the Amnesty Committee in connection with Operation Katzen make generous use of terminology such as permanently disappear, take out, get rid of, and similar expressions.
Nou, ek gaan nou lees paragraaf die beplanning van dokumente van die subkomitee vir die kwytskelding vir die Katzen, dat die bewoording van permanente verwydering, dat dit moet verdwyn of uitpaal of ontslaaf van raak en soortgelyke uitdrukkings.
And just to save time, I'm just going to summarize what the Truth Commission said. They said that applicant van der Westhuizen denied that such terminology was intended to mean killing.
Die bevindinge van die Waarheidsversoeningskommissie sê dat generaal van der Westhuizen dat hy betwist het dat die permanente verwydering die woorde eintlik beteken om iemand dood te maak.
And then I refer to paragraph 297.
Dan verwys ek na paragraaf 297.
Van der Westhuizen's testimony was contradicted by that of Brigadier Johannes Lodovicus Gqeberha, Divisional Commander of the Security Branch in the Border Region.
Die getuienis van der Westhuizen was dan weerspreek deur die van Brigadier Johannes Lodovicus Gqeberha, wat dan die bevelvoerder was van die sekuriteitsafdeling by die grensstreek.
Gqeberha testified that he had been instructed by his superiors to participate in Operation Katzen.
Gqeberha het ook getuig en gesê dat sy baas hom aangesê het om deel te neem in operasie Katzen.
He said that he had reservations about this, particularly after Eliso Lomzi started engaging in certain acts of terror.
Hy sê, hy het 'n bietjie gehuiwer hieroor, veral in die feit dat Eliso Lomzi begin het om sekere terroreur optrede uit te voer.
And I'm not going to read the rest of the quote, but Mr. Gqeberha goes on to say that he had an objection because the people that they were recruiting were being trained as terrorists.
En ek kan nie die hele paragraaf lees nie, maar meneer Gqeberha sê dat die mense wat hulle wou afneem, dat hulle opgelei was as terroriste.
So I want to put it to you that Operation Katzen envisaged acts of terror being committed, envisaged people being hurt, and envisaged people being killed.
En ek wil het aanstel dat die operasie Katzen gesien of voorsien dat daar dade van terrorisme uitgevoer sal word, mense sal seer kry en mense gedood sal word.
Your response?
Wat is u antwoord daarop? Hoe reageer u hierop?
Eerder, operasie Katzen was op aandrang gewees van president P.W. Botha, wat ook gehad het dat Lennox Sebi vervang moet word as die hoof van die Ciskei, verkieslik deur sy broer Charles Sebi.
My lady, Operation Katzen was initiated by P.W. Botha, wanted President Lennox Sebi to be removed and his place be taken by his son, Charles Sebi, or his brother.
Dis beteken dit vir my dat hy moes verwyder word, uit sy pos uitgaan, nie noodwendig dat hy moet doodgemaak word nie. Dit het ook nie gebeur dat hy gedood is nie. Hy is baie jare daarna eers dood.
And that meant that he should have been removed from his position, but not that he should be killed, because his demise only came many years subsequent to this.
Well, Mr. van der Westhuizen, Judge Zietsman took a different view. And, my lady, I'm referring to the Zietsman judgment. It's at volume B, Roman numeral 2, on page 46. It's page 6830 of the record.
Nou, regter Zietsman het heel wat verskillende mening het hy opgeneem.
And in relation to the options with respect to Lennox Sebi, Judge Zietsman had this to say: in my opinion, more than one of these options contemplate the possibility of Lennox Sebi being murdered.
En die regter Zietsman het gesê met betrekking die verwydering van meneer Sebi beteken eintlik dat een van die aanbevelings dat hy gedood moet word.
Ek wil weer sê, die bedoeling was nie om Lennox Saby die dood te maak nie, en dit is bewys deur die geskiedenis daarna.
My lady, again I say, removing did not imply that Lennox Saby should be killed, and that is evident from the subsequent events.
Well, let me put to you what Judge Zitzman commented on in his finding.
Laat ek net neem na die kommentaar wat regter Zitzman gemaak het in die lig van sy bevindinge.
What he writes as follows.
Hy skryf as volg. This one.
My lady, we had given the interpreter a copy of the extracts. It reads as follows. One of the documents is a report of a meeting held at Imzikaba on 10 November 1986, at which Brigadier van der Westhuizen was present.
Nou, een van die documenten wat teenwoordig is verwys na 'n vergadering wat in Gqeberha gebeur het en Brigadier van der Westhuizen was by gewees.
The document contains the following statements. Kwana Sebe Eital, hy is gevaarlik en sal Lennox Sebe oorneem. Lennox XS moet permanent uitgehaal word.
Kwana Sebe to be taken out because he is dangerous and he will replace Lennox Sebe. Lennox S must be permanently taken out.
And if I can continue, you may comment.
Ja, ek kan so vergadering onthou wat in die transkryp plaasgevind het. Dit was 'n taamlik groot vergadering, die detail daarvan kan ek nie onthou nie. Ek kan onthou wel dat Charles Saby teenwoordig was.
My lady, I do recall such a meeting, which was a big meeting in the Transkei, but I can't recall what the content of the meeting was, but I can recall the presence of Charles Saby there.
Ek kan miskien net byvoeg dat Charles Saby was die halfbroer van Lennox Saby.
I can perhaps add by saying that Charles Saby was actually the half-brother to Lennox Saby.
And so Judge Zitzman continues. In another document, the following appears. Colonel Zibi moet verdwijn permanent.
En dan gaan rechter Zitzman voor, hy sê in 'n ander document, verskyn die volgende. Kolonel Zibi moet verdwyn permanent.
And then Judge Zitzman on page 47 notes that part of the Katzen plan was implemented, which included a violent attack on the home of Lennox Sebe.
Dan sê rechter Zitzman dat die operasie Katzen was uitgevoer, want daar was 'n aanval op die huis van meneer Sebe.
And then finally, Judge Zitzman says the documents and the direct and uncontradicted evidence given by Colonel Duplessis constitute, in my opinion, prima facie proof that Brigadier van der Westhuizen was party to a plan that included as a possibility the killing of Lennox Sebe.
Dan gaan rechter Zitzman verder deur te sê dat die dokumente as 'n direkte wat nie weerspreek word deur die getuienis wat gegee is deur kolonel Duplessis, en dit hou die volgende in my opinie, en dit is ook 'n prima facie bewys dat Brigadier van der Westhuizen deel was van die plan wat dit insluit.
So, Mr. van der Westhuizen, I want to put it to you that the wording in the Katzen document, such as disappear permanent, that meant to kill, and you intended it to have that meaning.
En nou, ek wil dit aanstel, generaal van der Westhuizen, wat die woorde permanent verwyder beteken om iemand te dood. Permanent daardeur uit die gemeenskap te verwyder.
Julle, ek aanvaar dit in hierdie opsig dat ons in gedagte hou dat permanent is die teenoorgestelde van tydelik. So om 'n tydelike verwydering te doen, help nie. Dit moet 'n voortdurende wegneem wees.
My lady, I accept because permanent removal is the opposite of temporal removal. Temporal removal means that may come to an end, but permanent removal means it's an ongoing process.
Kan ek iets byvoeg?
Can I add something, my lady?
Yes.
Yeah.
Daar was 'n groot aantal mense by daardie vergadering in die Transkei. Wie wat gesê het en wie wat bedoel het, weet ek nie. En kan ek ook nie meer onthou nie.
There were quite a number of people that were involved in the Transkei meeting, my lady, and therefore I can't recall who says what, who suggested what, that I cannot recall.
But Mr. van der Westhuizen, the question really is, in the context of Operation Katzen, and here we're not concerned with lots of people being involved, we simply want to know from you, in the context of Operation Katzen, did the words permanent disappear mean to kill or not?
Has the witness not answered the question, Mr. Vani?
Die getuie die antwoord, die vraag beantwoord nie.
Did the witness answer in the affirmative, my lady?
No,
No.
but he has answered the question.
And my lady, just to be clear, is the witness denying that that meant to kill?
But
In my understanding, yes, Mr. Vani.
na my verstaan, ontken die getuie dat die woorde permanent verdwyn, dat dit die doodmaak van iemand behels.
Please confirm, Mr. van der Westhuizen, that you denied that the words disappear permanent meant to kill.
Lady, you've just
Cradock laat versleg of vererg.
2 town councillors have already resigned due to actions incited by Mr. Gqeberha.
2 staatsraadslede het reeds bedank weens die aggressiewe optrede van as gevolg van die optrede teen hulle deur meneer Gqeberha wat dit aangeblaas is.
Ek aanvaar dit so.
I accept it like that, my lady.
And just to put this minute in proper context, Matthew Gqeberha, Fort Kalata, Mbilelu, Gqeberha had been detained for some 6 months and they had been recently released.
En ook om hierdie natuurlijk in context te plaas dat Matthew Gqeberha, Kalata en die ander hulle was 6 maanden in hegtenis en daarna was hulle toe vrygelaat.
Ek kan meneer Gqeberha bevestig, die ander 3 name kan ek nie onthou nie.
My lady, I can confirm the detention of Mr. Gqeberha, but I can't recall the other names, my lady.
Yes, and given the minute here which says that the release of Gqeberha and his associates have worsened the situation, I want to put the following to you.
Nou, ook dit wat in die notules voorkom, was sê die vrylating van meneer Gqeberha en sy trawande die situasie te Cradock, laat versleg wil ek die volgende aan u stel.
And it is this.
En dit is dat.
In the words of the JMC meeting, security detention was not a permanent solution to the problems.
En die woorde van die GDS was die permanente aanhouding. Was dit die oplossing vir die situasie?
The problem, Mr. van der Westhuizen, with detention is that the detainees eventually get released.
Maar die probleem met die aanhouding, uiteindelik word die aangehoudes word hulle vrygelaat.
And then the situation worsens again.
En dan versleg die situasie weer.
Do you agree?
Stem jy saam?
Ek aanvaar dit so, ek kan onthou, daar was ander alternatiewe ook, soos verplasing of afdanking.
I understand that, my lady. There was also other alternative suggestions like transfer or other options for a person to be discharged.
Yes, we...
Excuse me, discharge nie.
Afdanken.
Ek het gesê, hy kan of verplaas word of heraangestel word.
Okay, what I wanted to say, it can be transferred or be reinstated again.
Excuse me, ek raak bietjie deur mekaar. Wat ek gesê het is verplasing en of afdanking. Dan word dat hy ontslaan word.
Yeah. I remember I'm getting confused. I was saying that a person can be transferred or alternatively a person's employment can be terminated.
Well, let's get to the question of their positions in the education department.
Kom ons gaan na die wat hulle gehad het in die onderwysdepartement.
And I'd like to refer you to the minute of another JMC meeting that took place on the 28th of March 1985.
Ek wil u neem na ander GDS-vergadering 20ste Maart van 19... Thank you so much. Van 1958.
Milady, this can be found at volume G, page 131.
Dit is volume G, 131.
And Mr. van der Westhuizen, if one looks at the people present at the top of the list as chairman is Brigadier C.P. van der Westhuizen.
As 'n mens kyk na die mense, die voorsitter daar, op die hoofpunt van die lys, is Brigadier C.P. van der Westhuizen as voorsitter.
Edele, dis reg.
Edele, my lady, that is correct, so.
And I want to refer you to item 7, titled Schools Situation.
Ek wil u verwys na artikel 7, wat praat oor die situasie in skole.
And I'm going to read to you items A, B, and C.
Dan gaan ek items A, B, C vir u lees.
Item A, a total schools boycott still exists in Cradock, Somerset East, Cookhouse, and Fort Beaufort.
Item A, daar heers nog 'n totale skoolboycott te Cradock, Somerset Oost, Cookhouse, en Fort Beaufort.
B,
my lady, I accept that as it is.
I'm going to read B and C together. Intimidation still occurs. The transfer of educators from Cradock is taking place. The educators were initially satisfied, but now they refuse to accept the new posts. It is apparently due to the influence of Matthew Gqeberha.
I'm reading, ek lees B en C, saam interpretasie van plaas. Die verplasing van die onderwysers van Cradock van plaas. Aanvanklik was die onderwysers tevrede, maar hulle weier nou om die nuwe poste te aanvaar, en dit is blykbaar as gevolg van die invloed van meneer Matthew Gqeberha.
So I want to put it to you, Mr. van der Westhuizen, that transfers don't work.
Ek wil het aanstel dat oorplasing het nie gewerk nie, werk nie.
That the teachers or headmasters in question can simply refuse to be transferred.
Die onderwysers, skoolhoofde, het net geweier om verplaas te word.
En ek aanvaar dit. Dit is ook, kom ek dink, aan ander moontlikhede soos afdanking of skorsing.
My lady, I accept that. That is why I said that there were other possibilities, like them being released from their duties or being suspended.
Well, I don't see how that how that helps you, Mr. van der Westhuizen.
Ek sien nie hoe dit help nie, meneer van der Westhuizen.
Because in actual fact, Mr. Gqeberha had earlier, in fact later in 1984, he was given a transfer to Gqeberha, which he refused and was dismissed.
En want meneer Gqeberha in 1984 wat hy 'n verplasing gekry na Cradock en hy het dit geweier om te neem. Wat gevolg was dat hy afgedank was.
And Mr. Kalata had also been dismissed, and these attempted transfers and dismissals did not help the situation.
En meneer Kalata het ook geweier oorplasing te neem en dit het nie gehelp nie.
So I want to put it to you that you and your colleagues knew well enough that transfers out of Cradock and dismissals from school did not work.
Nou ek wil dit aan u stel, u self en u lede of kommissie geweet dat verplasing of vanaf uit Cradock dat dit nie werk nie of afdankings.
U edele, dit kan ek nie bevestig nie.
My lady, I can't confirm that.
Let's move to the next document.
Kom ons gaan na die volgende document.
So this is yet another Eastern Province JMC meeting. And this one was held on the 23rd of May, 1985.
Dit is 'n ander GMS-vergadering wat op die 23ste Mei 1985 gehou was.
And my lady, this document can be located at volume G, page 139.
Nou, hierdie dokument kan volume G.
And Mr. van der Westhuizen, if we look at the list of persons present, you're again at the top of the list as Brigadier CP van der Westhuizen as chairman.
Meneer van der Westhuizen, as ons weer kyk na die bopunt van die lys, kom u weer eens daarvoor as die voorsitter.
Dat is korrek, edele.
That is correct, so my lady.
And if we can start at item number 16.
As ons kan begin by item nummer 16.
It's, well, I won't give the page number because it's paginated.
Ek gaan nou nie die bladsy nommer gee nie, want dit is gepagneer.
And just to summarize, it says by Lingelishle in Cradock.
Dat om dit op te som, sê dat het Lingelishle in Cradock.
Do you have item 16? Unfortunately, the interpreter's copy doesn't have the numbers, but I will read it out to you.
Yes.
By Lingelishle in Cradock, classes have been suspended.
Lingelishle, Cradock is klasse is opgesê. Dat is die suspend.
There are still demands for Matthew Gqeberha and Fort Kalata to be reinstated.
Daar is nog dit word nog steeds vereis dat Matthew Gqeberha en Kalata heraangestel moet word.
And then if we can turn to another paragraph, it's item 26.
As ons kan gaan na 'n ander paragraaf, dis item 26.
It reads as follows.
Dat lees as volg.
A signal report will be sent to the Secretariat of the State Security Council for submission to the relevant ministers.
Zijn verslag sal gestuur word na die sekuriteitskomponent dat dit deur kan voer na die relevante persone van die kabinet,
which says Matthew Gqeberha and Fort Kalata must never be reappointed again.
wat sê dat Matthew Gqeberha en Fort Kalata moet nooit weer aangestel word nie.
Edel is reg, ek onthou dit vaagweg, die nooit ooit lê by my 'n klok.
My lady,
En dit moet net in konteks gesien word dat hierdie wat oor skole geskryf is, deur insig te kom van die veiligheidspolisie en die departement van onderwys, wat dit kom meld aan die GBS.
that must be understood in context. The suspension of schools was a proposal from the security branch as well as Department of Education, my lady.
So,
Kan ek net byvoeg?
Can I just add, my lady?
En dit was ten einde die ondersteuning te kry vir die OPGBS om ook 'n aanbeveling in daardie verband te maak.
That was to support by the GMC, also to make a recommendation regarding that.
well, I want to put it to you
No, ek wil dit aan u stel
that you were in fact taking reinstatement off the table for Mr. Gqeberha and Mr. Kalata.
u het dit
That as follows, I'm translating into English.
ek dit lees as volg en ek vertaal dit in Engels.
The meeting unanimously decided that the following recommendations with regard to above-mentioned matters should urgently be brought to the attention of the Secretariat of the State Security Council and also for execution by the affected ministers before 25 May 85.
Die vergaderings het eenparig besluit dat die volgende aanbevelings tot die bovermelde aangeleentheid dringend onder die aandag van die CCVR gebring word en moet ook vir die deurvoering aan die dag van die CCVR gebring word. Die betrokke ministers voor die 25ste Mei in die jaar 1985.
Ek verstaan dit so, ek wil net doen dat beide van Rensburg en van Deventer was weermag generaals gewees.
I understand it like that, my lady, but both General van Rensburg and van Deventer, they were attached to the South African Defence Force.
En dat die, kan ek byvoeg,
Can I
en
add?
dat die verplasings, aanstellings, heraanstellings by die betrokke departement se lynfunksie in hierdie stadium of in daardie stadium onderwys en opleiding was. Hulle sou die aandag na daai betrokke minister toe deurgevoer het.
And also, that is the hiring or reinstatement or dismissal. That would have been referred to the Ministers of Department of Education and Training.
Yes. So paragraph A reads that Gqeberha and Kalata should under no circumstances ever be appointed in any post in the Department of Education and Training.
In paragraaf A word het gesê dat Gqeberha en Kalata onder geen omstandighede enige pos in die Departement van Onderwys en Opleiding ooit weer aangestel word nie.
Ek aanvaar dit so.
I accept that it is so. my lady.
And I'm also going to refer you to paragraph 4, which reads as follows. In both cases, press statements were already made by the relevant ministers that those affected should not be reappointed or readmitted, since the advantages and disadvantages attached thereto were thoroughly considered before the announcements.
In paragraaf 4 in beide gevalle was alreeds persverklaring deur die toegelaat en dat die betrokkenes nie heranstel of weer toegelaat sal word, aangezien die voor-nadele daaraan verbonden is deeglik voor die aankondiging oorweeg was.
And paragraph 5, the meeting is also of the opinion that continuous concessions in this regard would in any event not diffuse the situation.
Paragraaf 5 dat die vergaderings is ook aan die mening dat die gedurende toegewings dat dit geen in hierdie verband dat dit geen sinds die situasie sal ontlont nie.
So I want to put it to you, Mr. van der Westhuizen, that from the perspective of yourself and the JMC, as far as you were concerned, Mr. Gqeberha and Mr. Kalata should under no circumstances be reappointed again as teachers or headmasters.
Ek wil dit aan u stel. Uit u oogpunt in die van die GPS, meneer Gqeberha en Kalata nooit weer heraangestel word nie.
Ek aanvaar dit so, edele.
I accept it as such, my lady.
And then, perhaps as a result of your signal and the general context, it was decided to hold what's called a GVB AXI committee, an action committee on the 6th of June.
En moontlik weens wat u geïnitieer was daar weer 'n sekere aksiekommissie op die bene gebring.
Milady, there's a minute of that meeting at volume H, page 409.
Daar is minute van daardie vergadering.
And if I can refer you to item 5 from the minutes of that meeting, titled Situation in Cradock.
As ek kan verwys na item 5 van die vergadering in Cradock.
Yes, I'm going to read the paragraphs to you. So paragraph 5 reads, Mr. Stradom gives a report about his visit there and the interview with Matthew Gqeberha, a decision on the reappointment of Gqeberha in education. I read that as a decision has to be made whether to reappoint him or not.
En die situasie in Cradock, meneer Stradom doen verslag oor die besoek daar en die onderhoud met Matthew Gqeberha, die besluit oor die heraanstelling in die onderwys al dan nie van Gqeberha. Wat eintlik vir my sê dat Gqeberha nie weer aangestel moes word nie.
And then there is a decision that the AXI committee takes, which is that a committee led by the Secretariat of the State Security Council will determine Gqeberha's fate and do a presentation to the chairperson on 12 June 1985.
Dan is daar 'n kommissie van die secretariat wat sê Gqeberha nie weer aangestel word nie en daar sal 'n verslag doen sal plaasvind.
And just to round up, sorry to interrupt, just to let you know who was present at that meeting.
En net dat ek kan, hy was ook aanwesig geweest in daai vergadering.
The chair of the meeting was Deputy Minister Vlok.
En die voorsitter van die vergadering was adjunct minister Vlok.
And various people from the Secretariat, including Major General van Rensburg and a Mr. Stemmet.
En verskeie persone van daardie vergadering soos generaal van Rensburg en Stemmet.
Were you aware of this meeting?
Was u bewus van hierdie vergadering?
Nee, ek het reeds, en ek dink het was gister gesê, dat daar is verskeie OPGWS-vergaderings wat ek nie kon bywoon nie, en hierdie is een daarvan, ek het dit nie bygewoon nie.
My lady, as I've said yesterday, there are various JMC meetings that I couldn't attend, and this meeting was one of such meetings, my lady.
Yes, we can see from the list of people present that you were not there. The question is, were you aware that it happened?
Ons kan sien van die lys persone daar aanwesig, Maar was dat u nie daar was nie. Maar het u kennis gedra van hierdie vergadering?
Die edele nee, ek kan nie 'n vergadering onthou, teenwoordig of nie teenwoordig, waar minister, 2 luitenant-generaals en 'n klomp ander generaals teenwoordig was nie.
My lady, no, I can't recall a meeting where a ministers and 2 generals were present and other generals, my lady.
1, 2, 3, 4.
And then the very next... apologies.
As dit 7 generaals minister, ek persoonlik vind ek dit ongehoord. Ek het nooit so op die GWS bygewoon nie.
There are 7 generals, including the minister, but I never attended such a meeting, my lady.
So in fact, the very next day, the work committee that the AXI committee decided to establish, they met and deliberated on this question.
De volgende dag het die werkende komitee, die actiekomitee werkende komitee, wat dan oor hierdie aangeleentheid beraadslag het.
Dan net terug. Hierdie vergadering, ek sien nou, het plaasgevind by die polisie se hoofkantoor. En ek aanvaar dis die hoofkantoor in Pretoria.
But then I can see this meeting occurred in the head office, and I take it was the head office in Pretoria, my lady.
Yes, indeed, Mr. van der Westhuizen. And again, we never suggested that you were present at that meeting. It did take place in Pretoria.
Inderdaad, so meneer van der Westhuizen ons geensins gesuggereer dat u aanwesig was by daardie vergadering.
Then, my lady, the next document I'm referring to you is the record of the Works Committee meeting, which was held on 7 June 1985. It can be found at volume H, page 412.
De volgende vergadering moet ons nou gaan doen, is die van die werkende komitee, die 7de Juni 1985.
Mr. van der Westhuizen, at that meeting...
Nou, meneer van der Westhuizen, sorry.
Mr. van der Westhuizen, at that work committee meeting on the 7th of June 1985, they considered various options on what to do with Mr. Gqeberha, including reinstatement as a headmaster.
Nou meneer, in daardie vergadering van die 7de 1985 was daar verskeie opsies wat daarna gekyk was om weer meneer Matthew Gqeberha aan te stel as die hoof van die skool.
Were you
Kan ek praat?
Can I talk?
Please go ahead.
Yes, ek kan voortgaan.
Ek sien weer eens, dit is onder voorsitterskap van minister Vlok. En verder dat die Staatsveiligheidsraad aangewys is as die sameroeper van die komitee.
Maar
dit lyk my na 'n vergadering in Port Elizabeth nie.
Maar it appeared to me that the chairmanship was allotted to Deputy Minister Adrian Vlok by the working committee, and that also the security meeting, and that was a meeting on the 6th of June, and it would appear that it was held here in Port Elizabeth.
Yes, Mr. van der Westhuizen, we don't have to get into all that particular detail, but it is correct that the meeting of the previous day, which was chaired by Mr. Adrian Vlok, decided to set up a working committee to deliberate the future of Mr. Matthew Gqeberha.
Nou, ons hoef in die hele detail in te gaan nie, maar die vorige vergadering het besluit om 'n werkkomitee saam te roep en ook met 'n sameroeper wat die van die veiligheidstaak om te besin oor die omstandighede rondom meneer Koniwe.
So what I want to put to you, Mr. Van der Westhuizen, is that, in fact, you were aware of the 6th of June meeting in which Deputy Minister Vlok asked for a working committee to come up with recommendations on Mr. Ganiwe, and secondly, you were aware that that working committee met on the 7th of June.
Ek wil dat stel meneer Van der Westhuizen dat die bewus was dat die vergadering onder die adjunkt minister Adrian Vlok plaasgevind het, wat dan 'n werkskomitee aan die lewe geroep het om oorweging te skenk aan die aangeleentheid rondom meneer Koniwe, en dat u daarvan bewus was, u kennis gedra daarvan.
Ek het geen herinnering aan so 'n vergadering.
My lady, I don't have any recollection about such a meeting.
My lady, I see it is 1 p.m. Would this be an appropriate time for the lunch adjournment?
We'll adjourn for lunch to resume at 2 o'clock.
My lady, I wonder if I can perhaps ask for the court's indulgence, because it would be good if we can try and finish with this witness today. Perhaps could we start 15 minutes early? Would that be suitable?
Will that suit everyone concerned? Mrs. Coldman?
It's fine with us, Mary. There's just one request from us. Two of our colleagues live in Tata, and they still have to drive back. May they be excused? Advocate's number in Busabo.
Right. Can I make a suggestion that rather at 1:45 we meet in my chambers to forge the way forward in respect of this matter?
As the court pleases.
Right. The court, otherwise the court will resume at 2 o'clock. And your two colleagues can be excused, Mr. Pusako, Mr. Namba. Thank you very much. You are excused.
that detentions were not working, that they were not permanent solutions, and that transfers out of Cradock were also not working. They were not permanent solutions either.
Ek het het reeds vanoggend aan u gestel dat die aanhouding in die gevangenis nie sou werk nie, sowel as die verplaassing na buite Cradock, dat dit ook nie sou werk nie.
So what I want to put to you is that the only obvious and logical permanent solution can be murder.
En ek wil dit aan u stel, die enige logiese oplossing was 'n moord geweest.
Eerder ek kan glad nie daarmee akkoord gaan nie.
My lady, I can't go in accord, be in accord with that.
You can't be in accord with that. I don't know what you mean. Please explain.
As u sê, ek kan nie daarmee akkoord gaan nie, wat kan u verduidelik?
Eerder het gesê dat ek die moord bedoel, en dit is wat ek sê, ek kan nie daarmee akkoord gaan nie.
You just... Okay.
Ek het dit nie gesê nie, ek het dit nie geskryf nie, nie aan Van Rensburg of wie ook al nie.
You just mentioned the meaning of the words, and that is what I am in disagreement about. I didn't write it down, I did not say those words, I did not even write it to Van Rensburg.
Mr. van der Westhuizen, the face of the document says that this signal is from you. You authorized Colonel du Plessis to send it to the Secretariat of the State Security Council.
As 'n mens hierdie documents dien, hierdie sewende sê, dan kom dit voor dat u dit persoonlik laat versend na Van Rensburg.
Ek sê weer, die sein is opgestel nadat ek 'n oproep van generaal van Rensburg ontvang het.
My
Gaan
lady,
verder nou.
gaan maar voort.
Ek kan nie onthou wat hy my in daai gesprek gevra het nie. As ek na die sein kyk, glo ek, het hy gevra of wat is ons voorstel omtrent Matthew Corneli.
My lady, the signal came into being after the telephone conversation with General van Rensburg. And if my memory serves me well, the content thereof was an inquiry as to what we think about the situation regarding Matthew Corneli.
En die logiese ding wat ek gedoen het daarna is om die persoon wat met hierdie sake werk, naamlik Lawrence du Plessis, in te roep en voor te lig.
And what I did, it was to refer myself to the person who was working with this, and it was Lawrence du Plessis, so that he could bring me on board.
Well, in fact, the evidence of Lawrence du Plessis before the Zitzman inquest is that you authorized him to send this signal, including the contents of that signal, which called for the permanent removal from society.
Lawrence du Plessis se getuienis daar in die Zitzman commissie was tot die effect dat u opdrag gegee het dat hierdie sê opgestuur moet word na Van Rensburg toe, en dat die inhoud daarvan gaan oor dat Corneli doodgemaak moet word.
Well, I object to this question. It's factually incorrect. The evidence of du Plessis was that he is the author of the signal, and he sent the signal, and the content thereof was not shown to this witness nor discussed with this witness before he sent the signal. So it's factually incorrect what is put to the witness now.
So dit is feitlik nie korrek nie, wat na die getuie gestel is die beswaar, want Lawrence du Plessis se getuienis het gesê was die auteur van hierdie sein, en dat die hierdie getuie geensins gewys was of blootgestel was aan die inhoud daarvan.
Yes,
Well,
Mr.
milady, that is just preposterous. And in fact, there is a finding from Judge Zietsman that Colonel Lawrence du Plessis acted under the instructions of Brigadier van der
But
Westhuizen.
that was not the question. The question was that Mr. du Plessis informed the TRC that what you were putting to the witness, not the finding by Zitzman GP.
I don't follow that Mr. du Plessis put it to the TRC.
No, I understood your question to say, on the other hand, on the contrary, du Plessis testified that about what you put to the witness, that the witness is the one that knew about the signal. Wasn't that the question relating to what du Plessis had testified to?
Milady, the evidence before the Zietsman Commission was that Colonel Lawrence du Plessis acted under the instructions of Brigadier van der Westhuizen to send the signal as drafted, and there's a finding to that effect in the Zietsman.
I understood your question to say du Plessis had testified to that effect, and this is what the objection relates to.
Yes, before the Zietsman inquest, that is so.
Milady, it's not correct. We can look at the evidence of what my objection is about is that what was put to the witness, that he authorized the contents of this signal. The evidence of du Plessis was that before he sent the signal, General van der Westhuizen did not see the signal and was not aware of the contents. It is common cause, and I think the witness already testified to that effect, and it's in his statements, that he authorized or he instructed du Plessis to send the signal, but he did not see the signal or the contents thereof before it was sent. And that was also the evidence of du Plessis. So in as much as Mr. Varney suggests to this evidence to this witness that it was the evidence of du Plessis that the witness, General van der Westhuizen, was aware of the contents and then authorized it, it's incorrect.
Yes,
Milady, I don't wish to waste too much of the court's time on this. There's obviously a difference in the interpretation of the evidence before the Zietsman Commission, but between Mr. Van Zyl and myself, he's at liberty to make that argument. We will argue otherwise, that the contents of the signal was in fact authorized by Brigadier van der Westhuizen.
Lady, then I suggest Mr. Varney shows the witness that specific evidence of Colonel du Plessis so that we can look at it. I request him to do so.
Milady, we only have until 4 p.m. We will put up that evidence. I think, Milady, we should simply take note of the objection and the view of the witness that he never authorized the signal.
So you're suggesting that you will revisit the question at a later stage?
Yes. I'm simply going to put it
No, just give me a moment, please. Let's not all talk at the same time.
I'm simply going to put it to this witness that he did authorize the signal, and to the extent that he denies it, that he's not being truthful to this court.
No, I think it will only be fair to the witness to direct him to that evidence, Mr. Varney.
Vervelend is dat die getuie uitgewys word aan die hand van die dokumente voor die hof, waar dit aangedui word dat hy magtiging gegee vir die versend van die sein na van Rensburg.
Milady, my suggestion is that I will move on, and if we're able to find the references this afternoon, we'll revisit this point.
Ek suggereer dat ons aangaan en later, miskien 'n dag as ons hierdie punt Janne kry, dan gaan ons weer terug na hierdie punt toe.
Yes, proceed.
As the court pleases. Now, Mr. van der Westhuizen, I want to refer you to point 4 in the signal.
Nou, meneer van der Westhuizen, ek wil u verwys na punt 4 in hierdie sy.
Point 4 reads, wide reaction can be expected locally as well as nationally due to the importance of these persons, especially the former for the enemy.
Die sy lees as volg. 'n Wye reaksie mag nasionaal en ook plaaslik plaasvind weens die feit dat hierdie persone belangrike persone is in die gemeenskap.
So, Mr. van der Westhuizen, what would be this wide reaction that would flow from the recommendation to permanently remove?
Nou, wat is die verduideliking rondom die wye reaksie wat betrekking het op die permanente verwydering?
Edele, ek dink ek het dit reeds ook al gesê, ek het vir Du Plessis gesê, hy moet antwoord en implikasies aan sy antwoord koppel en uitspel, byvoorbeeld so, wat sal gevolge wees, en daardie skrywe soos byvoorbeeld paragraaf 3, seker ander ook, is wat hy geskryf het.
My lady, as I have said previously, I said to Lawrence Du Plessis he must continue as well as he must also incorporate the consequences and everything therein. And also with respect to paragraph 3, that you should give attention to that as well.
Well, I want to put it to you, Mr. van der Westhuizen, that if it was intended that there should be a detention of Mr. Gqeberha and the others, or a transfer out of Cradock, that would hardly have solicited a national reaction.
Maar ek wil dit aan u stel. Indien meneer Gqeberha miskien afgedank sou word, miskien verplaas buite Cradock, sodat geen sins of wye reaksie daar plaasgevind het nie.
Edele, ek sê weer, ek het nie die sin bewoord nie.
My lady,
Om interpretasie daaraan my te koppel, om dit woordeliks te verduidelik, is moeilik. Ek kan my opinie daar uitspreek as my opinie wil hê.
My lady, I am not responsible for the wording of the same. Safe to say, if you want me to come to hear what my opinion is about that, then you can ask me what my opinion is, but I'm not responsible for the wording.
Well, let's turn to your opinion, Mr. van der Westhuizen. Would a detention or a transfer out of Cradock attract a national reaction?
Nou kom ons kry u opinie. Aanhouding in die gevangenis of verplasing uit Cradock sou dit 'n wye reaksie uitgelok het?
Edele, ek aanvaar so, dit was dan selfs by die Staatsveiligheidsraad in Pretoria bespreek. En ek aanvaar dat die media gaan te ver.
I accepted, my lady, as such because this incident was also discussed by the security branch as far as Pretoria.
En ek is...
Sorry, my lady, I think the witness said the State Security Council, not the security branch, but the State Security Council. Yeah.
Thank you, Council, for that correction. That is the State
En ek wil net
Security
byvoeg,
Council.
Excuse. En ek wil net byvoeg dat die media in die Oos-Kaap sekerlik ook daardie berigte sou gedra het.
And I'm certain even the media in the Eastern Cape would have carried those news.
Well, I want to... Go ahead.
Excuse. En daaroor kon daar reaksie gewees het, korrespondensie gewees het, opmerkings gewees het.
And thereupon there would have been a reaction, correspondence, reactions.
Well, I want to put it to you, Mr. van der Westhuizen, that you are again being evasive, and in fact, the answer resides in 4B.
En ek sal dit weer aan u dat u weer ontwykend is en dat die antwoord is in 4B. Daar verskyn dit.
In fact, it's 4A.
Is eintlik 4
and it reads as follows.
En dit lees as volgt.
Interdicts as recently with Kurolozi, Hashe and Galela in brackets, PEPCO office bearers.
In interdikte met Kodolosi en Galela die PEPCO beamptes.
Now, let me tell you about the PEPCO 3, Mr. van der Westhuizen.
En ek is vertel van die PEPCO 3, meneer van der Westhuizen.
The reference to the disappearance of Kurolozi, Hashe and Galela, known as the PEPCO 3, is most telling because they were murdered by the security branch and their bodies burnt just 4 weeks earlier, between the 8th and the 10th of May 1985.
Die verdwijning van Kodolozi en Galela, hulle was deur die sekuriteitmagtes was hulle vermoor en dit was so tussen die 8 tot die 10de van Mei 1985.
And the interdicts referred to in the signal, those were very high-profile habeas corpus applications brought on the 19th of May 1985 before the Eastern Cape Local Division of the Supreme Court, the lady that was under case number 1803 of 85, by the families of the PEPCO 3 against the South African police to produce their bodies.
Daar was interdicts van die Hooggehalte op die 19de Mei 85 en dat ook by die Gramstad Hooggerechtshof was daar ook aansoeke van die families van die oorledenes dat hulle voorsien moes word van die liggame van die oorledenes.
The witness had indicated that those interdicts were, as you also point out, were directed at the South African police.
En dat sodanige interdict dan ook betrekking gehad op die Suid-Afrikaanse polisie.
So I want to put it to you, Mr. van der Westhuizen, that you were aware that the PEPCO 3 had been abducted, murdered, and their bodies burnt, and that is exactly what happened to the Cradock 4.
Nou, ek wil het ook aan die eet geweet dat die liggame van Kodolosi en Galela ontvoer was en uitgebrand was, en dit is presies wat met die Cradock 4 gebeur het.
And this is exactly what you had in mind, and this is what you wanted to avoid in relation to the Cradock 4.
En dit is presies wat u in gedagte gehad het, en dit is presies wat u wou gehad het wat met die Cradock 4 moet gebeur.
Ek ontken dit nie eerder.
I deny that, my lady.
Well, certainly if Mr. Gqeberha, Mr. Kalata and others suddenly disappeared like the PEPCO 3, you would agree that that, in fact, would instigate a national reaction.
Sekerlik as meneer Gqeberha, Kalata, die ander drie, as hulle ook moes verdwyn het, so daar 'n groot reaksie nasionaal uitgelok het, dink ek sal daarmee saamstem.
Ja, ek het reeds verduidelik en gesê dat dit was van belang selfs vir die Staatsveiligheidsraad wat in Pretoria sit waar dit bespreek is. Heel waarskynlik aanhangig gemaak deur die Departement van Onderwys.
I've already mentioned it was the Security Council that was based in Pretoria and also in connection with the Department of Education that was dealing with that aspect.
So I put it to you, Mr. van der Westhuizen, that if it was a detention or a transfer that was intended, those are the words that would have been used.
En ek stel dit aan u, as dit miskien aanhouding, verplasing, wat moes plaasvind, dan is dit die woorde wat so gebruik was.
Dit is nie my woorde nie. Ek weet nie waaraan dit nou gekoppel word nie.
My lady, those are not my words, so I don't know to what they should have been attached.
My lady, just for the record, my learned attorney has extracted a reference from the statement of Mr. Lawrence du Plessis, dated the 11th of March 1993, in which he says at paragraphs 5.1 and 5.2, the signal is authentic. The signal was drawn up by me as instructed by Brigadier van der Westhuizen.
Daar is nou net uittreksels wat my prokureur my voorgehou het van die 11de Maart 83, waar hy sê dat die sein deur my opgetrek is en ook deur my versend is.
My lady, that's at the record B2, page 4051.
Dit is nou daar vir die record B2, 51.
Lady, may we just have an opportunity to go to that page, please?
Yes, you may.
Okay.
Have you found that part, Mr. Van Zyl?
Yes, thank you, my lady. Yes, there's absolutely no allegation in that statement, which was also confirmed by Du Plessis in his oral testimony, that General van der Westhuizen saw the contents of the signal before it was sent. What is stated is that was in his statement. It's authentic, the signal. It was drafted by him and he sent it on instructions of Brigadier van der Westhuizen. No allegation at all that General van der Westhuizen was aware of the contents and approved the contents of the signal before it was sent.
Yes.
That was the basis of my objection.
Thank you. Yes, Mr. Vani.
My lady, we will find the evidence in which there was, I think, quite a detailed exchange on that issue. And the bottom line is that, at least in the finding of Judge Zietsman, he concluded that Colonel Du Plessis acted under the instructions of Brigadier van der Westhuizen, and that what was sent and what was reflected in the signal reflected the intentions of Brigadier van der Westhuizen.
Yes,
that will be our argument, my lady.
But yes, now we're concerned with what was allegedly stated by Mr. Du Plessis. I hear what you say about the finding, but as I say, the question was specifically directed at what was alleged to have been said by Mr. Du Plessis.
The allegation that Mr. Du Plessis didn't show Brigadier van der Westhuizen the contents of the signal, is that the allegation, my lady?
I think the question suggested that he was aware of the contents of the statement, that the witness currently before court now was aware of the contents of the statement.
Yes, and that is our assertion as well, my lady.
Lady, my learned colleague does not understand you. I'm putting to him that the question was that this witness was aware of the contents of the signal, and that's not correct. That was not the evidence of the scene. Du Plessis even went further and stated that there might be a 50-50 chance that he misunderstood the witness.
Lady, there is evidence from the Zitzman inquest, and we will find it in due course.
Yes, you have indicated that, Mr.
Yes. Well, I'm on a different aspect now, where the question was put to Brigadier van der Westhuizen as to whether Colonel du Plessis had ever departed from instructions that he had been given in relation to signals, and the answer was that he had not. And we would submit that this is a case in which Colonel du Plessis carried out the instructions from Brigadier van der Westhuizen as he intended.
Alhoewel ons hier vandaan afbeweegbaar was die kwelpunt met betrekking tot de Zitzman-commissie dat Lawrence du Plessis opdrachten uitgevoerd van generaal van der Westhuizen wat in die sein wat ook verzet was dat het zijn intentie weerspeel het. Dit is zijn doel, weerspeel het. Maar ons zal later van tijd, als ons die getuienis in die handen krijgt, zal ons dit dan aan die hof voorhouden. Want daarin zit du Plessis net ten opdrachten van een brigadier van der Westhuizen opgetreden.
Is going to comment on that, Mr. van der Westhuizen?
Meneer van der Westhuizen, wens u misschien om hierop commentaar te leveren wat nou net aan u voorgehouden is?
Ek is nie seker u edele dat ek alles korrek verstaan nie. Wat ek verstaan is, ek het vir die Plessis gesê om te antwoord op sy telefoonoproep. Die bewoording, die tekening, die opstel, die stuur van die sein, was in sy hand, ek nie die sein gesien nie. Ek kan nie kommentaar lewer op alles wat beweer word nie.
My lady, I don't know, actually, I don't understand what the question is, but what I say is that I did not draft the signal. I did not sign it. Safe to say, I left it in the hands of Lawrence du Plessis in order and to draft it, sign it, and to send it. And that was the culmination of a telephone conversation that I had with Van Rensburg, my lady.
Mr. van der Westhuizen, I totally understand why you would want to disassociate yourself from this particular signal, because on the face of it, this signal is a recommendation for an extrajudicial execution.
Ek verstaan hoekom u uself, meneer van der Westhuizen, wil disassocieer met hierdie sein, want hierdie sein dra eintlik 'n opdrag van mense wat moet uitgeneem word.
Ek gaan nie daarmee akkoord nie, ja, u edele.
I am in disagreement with it, my lady.
And are you in disagreement with it because, as per your earlier evidence, you suggest that the words permanent removal is not a recommendation for murder, but rather a lengthy detention or a transfer out of Cradock?
Nou, is die in akkoord daarmee nie? Is dit omdat u gesê dat die woorde permanente verwydering slegs die volgende bedoel, vir 'n lang tyd in aanhouding gehou word of miskien verplaas word uit Cradock?
Ek is steeds nie seker, maar klink my dit is in ooreenstemming.
I'm not certain,
Die
but
betekenis van reg.
no, you can continue. You can voortgaan, generaal.
Die betekenis van woorde en uitdrukkings moet in konteks gesien word. So ek is nie seker of mens verskillende kontekste aan mekaar kan vergelyk as dit verskillende omstandighede verteenwoordig nie.
Now, the question of the wording, I don't know whether we're at the stage of trying to bring two things together that are not in alignment.
Well, again, Mr. van der Westhuizen, and because we're short of time, I don't think we should beat around the bush. The fact of the matter is that a detention and or a transfer out of Cradock would not be permanent solutions. They would be temporary solutions. But murder, as in death, would indeed permanently remove them from society with no prospect of return.
Om recht naar de zaak toe te gaan, zou die
Lady, with full due respect, the
langdurige...
speech has been down more than one occasion.
Can you repeat that? I did not
So I
get
object. Lady, this question has been on numerous occasions and answered. I think that the witness should be further questioned in this regard.
Yes, Mr. Vani.
He said on numerous times he does not agree with it. So Afrikaans words were, ek gaan nie akkoord daarmee.
Yes, Mr. Vani.
Yes. Well, we're going to move from the signal, but we will be submitting to this court that your evidence in relation to the signal has amounted to lies under oath before this court.
Ons gaan wegbeweeg van hier te zijn af, maar ons gaan aan die hof voordoen dat die getuienis omtrent hier te zijn, dat dit alleen is hier voor die hof.
Yes, you can move on, Mr. Vani.
Yes, my lady, we're now going to move to another document.
Ons gaan nou naar een ander document.
My lady, this is at volume H, page 439. It is a meeting of the State Security Council at Take's Cape Town on the 10th of June 1985.
Dit is een vergadering van de Veiligheidsraad in Tuinhuis op de 10e van juni 1985.
Now, to be clear,
Did you
Mr.
get the reference, Mr. Fonseca?
Yes, thank you, my lady, we have it.
Thank you. Yes, Mr. Vani.
Now, to be clear, Mr. van der Westhuizen, just so that we don't waste time on this issue, we're not suggesting you were at this meeting. This was a meeting of the State Security Council.
Net om duidelijkheid of opklaring te geven, ons suggereer geen sins dat u deel was van hierdie vergadering nie, maar net om aan u aan te dui dat dit 'n vergadering was van die Staatsveiligheidsraad.
Ja, Gqeberha.
Yes, my lady.
So individuals who were present included Mr. Gqeberha, F.W. de Klerk, Law and Order Minister Louis Lagrange, Defence Minister Magnus Malan, Minister of Finance Baron du Plessis, and Deputy Minister of Law and Order Adrian Vlok.
So al hierdie vermelde persone, Gqeberha, Adrian Vlok en die ander name wat die voorgehou was, is die ledes wat hierdie vergadering bygewoon het.
Ja, Edel, sover ek weet, is dit 'n redelik verteenwoordiging van die samenstelling van die Staatsveiligheidsraad.
Yes, my lady, it is quite a composition of quite a number of people, the State Security Council.
And I want to draw your attention to agenda item 3, which is titled Matters Arising from the Minutes.
Dan wil ek u verwys na een van die agendapunte wat sê sake voortspruitend uit die notulen.
We're going to be looking at item A,
Ons gaan kyk
which is titled Information Briefing Discussion with JMC chairpersons.
ons gaan nou na titel waar hulle sê is dit inligting rondom met die voorsitter.
Now, I want you to note the timing of this meeting.
Ek wil net dat jy moet kyk na die tyd wanneer hierdie vergadering so plaasgevind het.
It's on the 10th of June, barely 3 days from the signal that you authorized, suggesting the permanent removal from society of the three.
Dit is op die 10de van Junie, 3 dae voor die sein wat saamgestel was deur self van die permanent, die aanbeveling van permanente verwydering.
And the item reads as follows.
En hierdie item lees as volg.
Deputy Minister Vlok reports that he has spoken to the GBS chairman and that it was clear that they sometimes have problems that departmental representatives do not have the necessary instructions or delegations to act on their own initiative.
Adjunct Minister Adrian Vlok doen verslag dat hy met die GBS voorsitter gesels het en dat dit duidelik was dat hulle soms probleme het dat die departementele verteenwoordigers nie die nodige opdragte van die delegasies het om op eie inisiatief op te tree nie.
The Secretariat has now arranged that where such actions are urgently necessary, the GBS chairman will submit their plans directly to the relevant departments at a meeting where Deputy Minister Vlok is also present and where departments will then deliberate together on the best course of action.
Die sekretariat het nou gereël dat hulle waar sulke optrede dringend noodsaaklik is, die GBS voorsitters hulle planne direk aan die betrokke departementele voorlê by die 'n vergadering waar adjunct minister Vlok ook teenwoordig is en waar departemente dan saam besin oor die beste optrede.
And it is expected that this method will bring about faster action by the relevant departments.
Hy spreek die vertroue uit dat die metode sneller optrede deur betrokke departemente sal bewerkstellig.
So it appears, Mr. van der Westhuizen, that Deputy Minister Vlok was putting in place a process whereby the JMC chairman, including yourself, could take initiative. You'd have the authorities or delegations to act on your own initiative, and you would simply have to clear it at a meeting with the Deputy Minister Vlok.
And it break us off.
But that's not correct, lady. That's not what is said in that paragraph. The chairmen can act on their own initiative and to inform the departments. So that the GBS chairmen may provide their directly to the part at a meeting where the Deputy Minister is present. The chairman of the JBS meetings that can act on their own. It's not good. That is what Mr. Varney wants to convey.
Well, actually, my lady, that's precisely what I read out. Perhaps my learned friend didn't hear me. But yes, I agree that the GBS chairpersons would have to submit their plans directly to the relevant departments at a meeting where the Deputy Minister Vlok is present.
Dit is korrek sodat hierdie voorsitter van die GBS hulle planne moet voorlê in 'n vergadering waar die adjunct minister Vlok teenwoordig is.
Now, what I want to put to you, Mr. van der Westhuizen,
Wat ek aan u wil stel, meneer van der Westhuizen,
is that this appears to be an initiative by Deputy Minister Vlok
dit kom voor dat dit 'n inisiatief is van die adjunct minister Vlok
to allow the GBS chairpersons to act without necessarily having to get clearance from higher authorities, aside from the meeting presided by Deputy Minister Vlok?
Dat die GBS-voorsitter kan optree sonder dat hulle enige magtiging kry op hulle eie, buiten dat hulle kan rapporteer in 'n vergadering waar adjunct minister Adrian Vlok is.
And the department.
And the department. Thank you.
So it does seem that Deputy Minister Vlok was engineering a situation that would allow the senior persons, particularly in the State Security Council, to come up with plausible deniability that these actions were taken without their knowledge, because it simply stopped at the level of Deputy Minister Vlok.
Dat wil voorkom asof adjunct minister Vlok hier met 'n inisiatief kom waar hier die voorsitters met hulle eie planne na vore te kom sonder dat die hoër gesag daarna kennis dra, want dit eindig alles by adjunct minister Vlok.
Do you agree with that proposition?
Stem u saam met dit wat aan u voorgehou word, generaal, of stem u nie saam nie?
Nee, dit maak nie vir my sin nie. Ek het reeds getuig dat die GBS geen uitvoerende gesag gehad het nie. Ek kan nog praat.
No, because I already said in my evidence that the GBS did not have any mandate to execute or authority to execute decisions.
Departementele uitvoering rust by departemente.
Now,
Nie by die GBS nie.
the departmental executions resonated with the departments and not with the GBS, GMC.
Yes, I
Die
don't think...
GBS, ek is nog nie klaar nie.
Okay.
Please continue.
Die GBS het 'n koördinerende funksie gehad. As u wil gaan na 'n besluitnemingsinstansie, dan moet u na die Staatsveiligheidsraad toe gaan waar die ministers op sitting gehad het en selfs die staatspresident op sitting gehad het en baie keer as voorsitter opgetree het.
Now, the GMC did not have the authority to execute any decisions, save for the fact that if you wanted a forum that could come to the decision, it was the State Security Council, where the minister as well as the Prime Minister, they had sitting rights.
Yes, Mr.
Lady, sorry to interrupt. The witness indicated to me that he would just like to take a short break. If we can maybe just adjourn for 10 minutes.
Thank you. We'll adjourn for 10 minutes.
Thank you, lady.
Generaal, die u word
Thank you, my lady. We thank you for the short adjournment.
You are reminded, General, that you are still under oath to tell the truth. U word gemaand, Generaal, dat u nog steeds onder eed is om die waarheid te praat. Bevestig u dit so?
Ek bevestig so, edele.
The witness has been placed under oath, my lady.
Thank you. Yes, Mr. Van.
As it pleases the court, my lady.
Thank you.
As the court pleases. Just to round up the story, Mr. van der Westhuizen.
Om net hierdie storie af te rond, meneer van der Westhuizen.
So on the 7th of June, you authorized the sending of a signal requesting the urgent permanent removal of Mr. Gqeberha, that's Matthew and Imbelela Gqeberha, as well as Fort Kalata. And then just 2 days or 3 days later, the State Security Council, through the offices of Deputy Minister Vlok, seeks ways in which he can assist chairpersons of the JMCs to act without having to go higher than having a meeting with him.
Ons is nou hier, meneer van der Westhuizen, by die site wat u self opgestuur het, wat betrekking het op die permanente verwydering van meneer Gqeberha, Kalata en die ander wat daar ook betrokke was. En dat 3 dae daarna was die inligting versend na die Staatssekuriteitsraad, waarna moes gekyk moet word na die maniere hoe daar uitvoering gegee kan word aan hierdie aanbeveling.
And then just over 2 weeks later, on the 27th of June,
2 weke
the 3 individuals and, 4 individuals, including Mr. Gqeberha and Mr. Kalata, are in fact abducted and murdered. Is that not suspicious, to say the least?
En op die 27ste van Maart het die 4 persone Gqeberha voor Kalata en die anders was hulle ontvoer en hulle het toen net verdwyn. As dit nie, is daar nie agterdog in dit nie. Of toevallig.
Daar kan sekerlik agterdog wees. Ek kan nie onthou dat ek enige agterdog gehad het daaroor nie.
Certainly there could have been a suspicion, but I'm certain I did not have any suspicion relating to that, my lady.
So you can understand why others might have had a suspicion, but you yourself had no suspicion whatsoever?
Meneer, ek kan verstaan hoekom daar agterdog geheers het met die ander, maar u self het geen agterdog gehad nie.
Edele nee, ek dink toe dit later bekend geword het hoe en wie daarvoor verantwoordelik was, toe kon agterdog by my ontstaan het.
My lady, no. Only at some later stage, when it came to light, was involved and was responsible. It was only at that stage that suspicion could prevail with me, my lady.
And at what stage was that?
En op watter stadium was dit gewees?
Dit kan ek nie onthou nie, edele.
That I cannot remember, my lady.
But did you start to get suspicious maybe days or weeks or perhaps months after the murders?
Het jy begin
Lady, the witness just said he can't remember. There's no purpose in him speculating about that. He says he can't remember.
Yes, Mr. Van.
die getuie het net gesê kan nie onthou nie. Dit sal nie help om daaroor te spekuleer nie.
Well, my lady, this is an inquiry, a truth-seeking exercise, and typically when a witness says you can't remember a particular time, one tries to assist the witness by saying, well, are we talking days weeks or months. Of course, he's entitled to say he has no clue, but I think at least we should be permitted to try.
I think you should ask the next question, Mr. Zani.
As the court pleases. When you heard about the murders of the four, including Mr. Gqeberha and Kalata, who appeared in the Signal, what was your reaction?
Toe u nou verneem het van die dood op die 4, meneer Gqeberha en Kalata, wat was u reaksie daaromtrent?
Ek het die sein gesien in 'n uitgawe van die koerantjie New Nation, ek dink. Dit was baie lank daarna gewees.
I saw the Signal in
En omdat in daardie sein wat gepubliseer was, meneer Gqeberha se naam genoem gewees het, kon ek terugdink aan die tydperk toe ek in Port Elizabeth was, toe Gqeberha ter sprake was.
I saw the sign in a newspaper which was called, that is the New Age, and because of the name of Mr. Gqeberha that appeared there, that triggered my recollection. But it was a long time after that, my lady.
Can you recall what your reaction would have been or was?
Nou, kan u onthou wat u reaksie was, hoe u daarop reageer het?
Dit is moeilik om te sê ek kan per se onthou, maar ek kan glo dat ek ontstig was daaroor, omdat dit in my komandement gebeur het, toe ek daar was, en ek weet nie daarvan nie.
I can't tell, my lady, what my reaction was. Safe to say, I was upset about it because it occurred without my knowledge, and I wasn't there.
Mr. van der Westhuizen, at the time, you were officer commanding of the Eastern Province Command, and you were also the chairperson of the JMC, and you sat on the executive of that organization. You would surely have received news of the murders, if not within hours, then at least within a day or so.
Nou, meneer van der Westhuizen, u was die voorsitter van die Suid-Afrikaanse weermag. U was ook die voorsitter van die GBS, en sekerlik binne ure of dae moes die berig aan u oorgedra was van die dood van hierdie 4 persone.
Ek kan dit aanvaar, ek kan nie vir u sê wanneer ek dit presies so gehoor het nie.
My lady, I can accept that, but I cannot say precisely as to when I came to hear about it, my lady.
Well, it's almost certain that the South African police or the security branch, either in a communication or a meeting, would have raised the fact that there had been 4 murders falling within your jurisdiction, and that within a few days you would have learnt the identities of the individuals, and that 2 of them were mentioned in the Signal.
Meneer, dit is vanselfsprekend dat dit tussen die Suid-Afrikaanse polisie, sowel as die veiligheidsmag, dat daar gesprek gewees het omtrent hierdie ding, en dat u miskien, al is het 4 dae later, sou verneem het wie die name van die persone was, wat vermoor is, van 2 van hulle se name, namelijk Mr. Gqeberha en Kalata, word in sein 7 vervat.
Ja, ek verstaan nou beter. Dit was ook in die media gerapporteer gewees, en ek is sekerlik dat dit by die GBS ook te berde was.
Yes, my lady, I understand it better now, because it was also noted in the GMC
So,
what as something that featured within the South African police as well as the security branch.
so I ask again, Mr. van der Westhuizen, what was your reaction?
Weer eens vra ek, wat was u reaksie gewees toe u te kenne kom van hierdie voorval?
Die edel is baie lank terug om 'n reaksie te beskryf, maar ek kan glo dat ek geskok was.
My lady, it is quite a very long time back to remember what my reaction was, but I can believe that I was shocked.
Well, I'm assuming you were shocked because on your version, that was not a recommendation to murder. It was either a detention or a request for a transfer.
Ek neem aan dat u geskok was, want dit was die aanbeveling. Die aanbeveling was liewer 'n langtyd in aanhouding of verplasing.
Die edel nee, as ek sê ek was geskok, dan is ek geskok soos wat enige burger was wat dit in die koerant gelees het of op die nuus gehoor het. Ek dink dit enige iemand wat dit gehoor het, sou daardeur geskok gewees het.
My lady, no. When I say I was shocked as it would have been with any citizen who read about it in the newspapers. That was the shock that I had, a shock which would have been a general shock which everyone would have experienced.
Well, Mr. van der Westhuizen, you are being evasive again, but let me put it to you that if you were genuinely shocked that these two individuals who had been mentioned in the signal ended up murdered, that you would have investigated as to what transpired.
Nou, meneer van der Westhuizen, weer eens is u ontwijkend. As u geskok was en u was eerlijk geskok, dan sou u 'n ondersoek geloods het om dan te bepaal wat gebeur het.
There would have been
Nee, dit is nie so nie. Ek is 'n lid van die weermag. Ons ondersoek nie misdade of vermeende misdade nie. Dit is die taak van die veiligheidspolisie en selfs die polisie self.
My lady, no, I'm a member of the South African Defence Force. That would have been the duty of the South African police or the detective branch, because I'm not in my capacity chasing after criminals or persons.
En kan ek asseblief byvoeg, ek sou ook nie en ek het ook nie 'n ondersoekspan aangestel om 'n ondersoek in te stel nie.
And can I add, I did not even establish an investigating team to do this, an investigation regarding the incident.
Well, I want to put it to you, Mr. van der Westhuizen, that if you were genuinely shocked that the two individuals who you thought you were recommending for detention or transfer ended up murdered, you would have at least been asking questions as to why it was that they were not detained or transferred, but ended up dead.
Nou, ek wil dit aan u voorhou, generaal van Rensburg. As u werklik geskok was dat die persone wat u gedink het moes in aanhouding was vir 'n lang tyd of verplaas was, hulle is nou vermoor, u moes daarom vrae gevra het en u moes daarom tipe van 'n ondersoek geloods het om uit te vind wat so gebeur het.
Eerlik wil weer beklemtoon, ek het nie 'n ondersoek geloods nie. Nie persoonlik nie, ek het niemand aangestel om 'n ondersoek te loods nie. Ek het soos 'n normale landsburger daarvan te hore gekom.
My lady, to be honest, I did not set up an investigating team, and myself personally did not do any investigation. I was shocked, like any citizen of the country, after I came to hear about this incident.
I put it to you, Mr. van der Westhuizen, that you're not being truthful with this court.
Ek stel dit aan u, meneer van der Westhuizen, dat u geensins die waarheid hier voor die hof praat nie.
U wil dit ontken ek. Ek vra die waarheid.
My lady, that I deny. I'm telling the truth.
My lady, I'm just going to refer this Honourable Court to certain passages relating to the interaction between myself and my learned friend on the question of the role of Lawrence du Plessis and what he did at the time.
Ek het nou net verwys dat dokument wat ek met my geleerde vriend opgeneem het met betrekking tot die rol van Lawrence du Plessis en wat hy ook daardie tyd sou gedoen het.
I will then seek the comment of the witness.
En ek sta die kommentaar van die getuie.
So, my lady, we're going back to Mr. Lawrence du Plessis' statement at B2, page 4053.
Ons gaan terug na die getuienis van Lawrence du Plessis.
And I'm going to refer to paragraphs 10 and 11.
Dan wil ek verwys na paragraaf 10 en 11.
And I'm first going to read the whole of paragraph 10.
Ek first going to read, ek gaan eers lees die hele paragraaf 10.
Brigadier van der Westhuizen instructed me to prepare a signal report and send it to General van Rensburg in which telephone conversation is confirmed and the proposal is explained. Secondly, the names of the persons concerned are mentioned. And thirdly, the possible implications of the proposal are set out.
Brigadier van der Westhuizen het my opdrag gegee om 'n seinberig op te stel en aan generaal van Rensburg te stuur waarin 'n telefoongesprek bevestig word en die voorstel uiteengesit word. Ten tweede, dat die name van die betrokke persone gemeld word. 3, die moontlike implikasies van die voorstel uiteengesit word.
Your comment on that paragraph?
U kommentaar op daardie paragraaf?
Ek aanvaar dit verwys na wat ons noem die sein.
My lady, I accept that it refers to what we call the signal.
Yes, indeed.
Ja, inderdaad so.
Dit lyk dan vir my korrek, U Edele.
Then it appears to me to be correct, my lady.
And then paragraph 11, immediately after receiving the order, I returned to my office where I drafted the signal report. Immediately after I drafted the signal report, I had it sent. I wish to state once again that, although I cannot remember it specifically at present, I would probably have made a contemporaneous written notes of Brigadier van der Westhuizen's order in order to be able to carry it out correctly.
Paragraaf 11, ek het onmiddellik na die ontvangs van die opdracht teruggekeer na my kantoor waar ek die seinberig opgestel het. Onmiddellik nadat ek die seinberig opgestel het, het ek dit laat stuur. Ek wens dat weer eens te meld dat alhoewel ek nie dan spesifiek kan onthou nie, sou ek waarskynlik contemporaire skriftelike notas gemaak het van Brigadier van der Westhuizen se opdrag ten einde dit korrek te kon uitvoer.
Your comment, please.
Ek kommentaar asseblief.
Julle kan aanvaar, ek kan nie onthou toe ek van gesê het om die sein te stuur of hy notas gemaak het of nie.
My lady, I will accept, but I can't recall when I ordered him to send the signal, whether I made notes or not.
And the final passage is from the judgment of Judge Zitzman.
En die finale gedeelte is uit die uitspraak van Edele Zitzman.
My lady, the Judge Zitzman discussed this interaction at length between pages 72, 75. But I'm just going to read the conclusion he reached at the bottom of page 74.
Nou, regter Zitsman bespreek die aangeleentheid hier baie wyd, maar ek gaan net begin by 74.
In my opinion, it has been established prima facie that the signal was intended by Colonel du Plessis to mean that Matthew Gqeberha and the others should be killed, and also that this is the meaning that Brigadier van der Westhuizen intended should be conveyed in the signal.
En na my mening was die sein, sy intentie deur kolonel du Plessis beteken dat Matthew Gqeberha en andere moet vermoor word, en ook dat dat dit beteken dat Brigadier van der Westhuizen sy intentie is dan oorgedra in die sein.
Nee, ek ontken dit.
My lady, I deny that.
Lady, if I just may interject for a moment, that's with reference to the evidence of Colonel du Plessis and the statement of Colonel du Plessis that the witness was confronted with by Mr. Barney. Just for the record, I want to place it on record that we are obviously not in a position to cross-examine Colonel du Plessis on that statement or anything that he said, whether recorded in his statement or during his evidence, because he passed away. That is, we submit prejudicial to our client, but I just want to place that on record. Thank you, madam.
That has been noted. Yes, Mr. Ivan.
Ek wil dit net op record plaas dat hierdie verklaring van kolonel du Plessis waarmee die getuienis nou gekonfronteer word, hy is nie meer daar waar ons hom onder kruis verhoor kan neem nie, want hy is oorlede. En ek wil dit net op record plaas, want dit kan ook nadelig wees vir my kliënt.
Yes, that is noted, my lady. It's also regrettable that Colonel du Plessis is not with us any longer.
Ja, neem kennis daarvan, en dit is ook met leed wees, want kolonel du Plessis is nie meer saam met ons nie.
Yes, President.
In conclusion, Mr. van der Westhuizen, I want to put it to you that the signal that you authorized on 7 June 1985 was a request to kill the 3 persons.
Ten einde, ten slotte wil ek het aan u stel dat die sein wat u deurgestuur het op die 7de Junie 1958 was dan 'n opdrag om die 3 persone te vermoor.
And second,
Excuse, ek ontken dit.
My lady, I deny that.
secondly, you foresaw, you had the foresight that a signal of that nature, with the language used, could very well result in the murder of the individuals listed?
Nou, meneer, u het voorsien, en u was daarvan bewus dat sy van daardie aard, en veral as 'n mens kyk na die taal, daarin vervat sou dit lei na die moord op die op persone.
Edele, eweneens ek ontken dit, en ek het reeds getuig dat ek nie die sein gesien het nie, ek het nie die gesein geskryf nie, ek het nie die gesein bewoord nie.
My lady, I deny that because I did indicate before, I did not send the signal, I did not draft the signal, I'm not responsible for the wording thereof, and I did not sign the signal, and I didn't send it.
Mr. van der Westhuizen, you reconciled yourself to the risk that people might be murdered. You accepted that risk, and nonetheless, you persisted with it.
Meneer van der Westhuizen, u het uself eenselfig met die risiko dat mense so vermoor, ten spyte van die feit dat u daarvan bewus is, en u nogtans u daarmee vereenselwig.
Edele, nee, dit is verregaande om so iets te sê, en ek ontken dit ten sterkste.
My lady, no, that is total exaggeration to go as far as that, and I completely deny that.
No further questions, my lady.
Thank you. Are there any questions for the witness? Do we have Mr. Gqeberha online, or Ms. Buthelezi, or any other counsel who would like to ask questions from the witness?
Thank you, my lady. Mr. Gqeberha is still held up, but I have very few questions for the witness. I won't be long, my lady.
Meneer Gqeberha is nog besig, maar ek het net 'n paar vrae wat ek met die getuie wil opneem en ek gaan nie lank wees nie.
Yes, go ahead, Ms. Buthelezi.
Yes, ek
Thank you, my lady. Mr. van der Westhuizen, do you accept that in the absence of memory, concurrent official documents serve as the best evidence?
Meneer van der Westhuizen stem u saam in die lig van die feit dat u geheue nie meer so goed is dat die huidige dokumente dan dien om u geheue te verfris?
Lady, I object to the question. She's seeking a legal opinion from the witness. And it's for your ladyship with respect to decide what is the best evidence, having regard to all the evidence before you.
Ek maak beswaar teenoor die vraag, want dit is nou 'n regsopinie wat van die getuie uitgelok word, en dit is die edele se taak om dan sodanige bepaling daaromtrent te maak.
Yes, Ms. Buthelezi, isn't that the case?
As dit nie so nie, Buthelezi.
Thank you, my lady. I will rephrase the question. Mr. van der Westhuizen, do you accept that even if you can't personally recall the writing and drafting or seeing of the signal, it was created in the ordinary course of operations by the competent office?
Nou, meneer van der Westhuizen, al kan u nie ontdoen nie, maar aanvaar u dat die samenstelling van die sein, bewoording, onderteken, en daarvan dat dit gebeur het in die verloop van die normale operasie.
Edele, ek is jammer, ek verstaan nie die vraag nie. Watter normale operasie word nou verwys?
During the course and scope of Mr. Du Plessis' duties.
Dit is toch gedurende die omvang en van meneer Du Plessis se pligte.
In daardie konteks, meneer Du Plessis, of commandant Du Plessis, was sekretaris van die OPGBS, so hy sou die opinie of die mening of die aanbevelings kon oorgedra. So in daai konteks verstaan ek dit. Ek weet nie in watter ander konteks ek dit nou moet verduidelik nie.
Now, in the context for decades, Mr. Du Plessis was attached to the DPS, so was able to formulate it as well as to attach his opinions thereunto, and I don't know in what context I need to understand that.
Okay, I'll clarify. It's really a simple question, and it goes to the legitimacy of it. Did it pass the normal course that any other signal would have passed? Was it authorized?
Ek gaan dit weer anders omstel. Die enigste bepaling wat ek wil bepaal, of dat die normale gang van die normale prosesse wat enige sy moet deurgaan, dit is wat ek wil uitvind.
Ek probeer dink aan die prosesse. Ek het 5 kolonel stafoffisiere gehad wat syne en korrespondensie hanteer het.
I had officers who were dealing with signals as well as correspondence.
Okay, I'm going to move on.
Okay.
Yesterday, you gave Mr. Coltman details of the conversation that you had with Mr. van Rensburg, and you said that he needed a written briefing, an explanation regarding who was involved in the education system in Cradock, and that you only gave him Matthew Goniwe's name and not the other two names.
Gister het u van meneer Coltman die detail gegee omtrent die lijstname van persone en ook die inhoud van die site en die enigste naam wat deurgevoer was die naam van Matthew Goniwe. Dit is nou met betrekking die interaksie met die departement van onderwys.
Now, is there any specific intelligence report or minute that you relied upon on the 7th of June, 1985, to identify Matthew's name?
Is daar enige intelligensie verslag of minuut waarop u gesteun het om dan die naam van Matthew Goniwe dan te kon identifiseer?
Ja, ek dink ek volg nou. Dit was wel by die OPGBS genoem gewees. Ek kan nie mooi onthou nie, maar ek dink ek het dalk Fort Kalata se naam ook genoem. Hoe dit ook al sê, ek het dit aan Du Plessis oorgelaat om die name te bevestig en by te voeg waar nodig.
I understand now, because it was a subject of discourse in the GMC, and secondly, the names of Goniwe as well as Fort Kalata came to be mentioned, and then that entire process, I left it in the hands of Colonel Du Plessis to formulate as well as to give his opinions or to make edifications where it's necessary.
So I think I understand that you said you only gave Matthew's name because that was the only name you recalled, but now you're saying that you relied on certain minutes that also named Fort Kalata's name. Is that correct?
Ek het gister verstaan dat u sê, u het alleenlik melding gemaak van Goniwe se naam, maar nou sê u dat u gesteun het op minuut of 'n verslag waar daar ook melding gemaak was van meneer Fort Kalata se naam.
Edele nee, dis wat ek gesê het. Ek het meneer Fort Kalata se naam moontlik onthou. Ek kon dit vir hom genoem het. Ek weet nie of ek dit gedoen het nie. Maar dit is moontlik dat ek dit kon gedoen het omdat ek geweet het van hom.
My lady, no. I said I could have mentioned the name of Fort Kalata, but I'm not certain. But it could have happened that I did mention his name because of the fact that I was aware about him.
Well, Mr. van der Westhuizen, that was not your evidence yesterday, and at some point we will refer to the transcripts. Yesterday, you specifically said you only gave Matthew Goniwe's name.
Meneer van der Westhuizen, gister was dit nie u getuies nie. Ons kan die transkripsies deurgaan, maar het gister gesê dat hy alleenlik Matthew Goniwe se naam deurgevoer het.
Maar ek sê mos, ek het Goniwe se naam genoem en dit is moontlik dat ek Fort se naam kon bygenoem het. Ek kan nie onthou of ek sy naam bygenoem het of nie bygehou het nie.
My lady, what I'm saying, I did mention Goniwe's name, but that it is possible that I did make mention of the name of Fort Kalata, but I can't recall whether I did mention his name or not.
I'll move on to my next question. Mr. van der Westhuizen, can you point this court to any official document where permanent removal from society meant detention or administrative reassignment?
Now, meneer van Rensburg, kan u enigsins 'n dokument toon wat aandui dat permanente verwijderen, dat het betekent verplaatsing of iemand een aanhouding gehouden wordt voor een lang tijdperk als een administratieve verloop.
Nee, edele, ek kan nie nou na 'n dokument verwys nie. Ek weet nie van so 'n dokument nie.
No, my lady, I can't refer to such a document because I'm not aware of such a document, my lady.
So, is it correct, Mr. van der Westhuizen, that if you claim that the words meant detention, you are unable to point to any official concurrent document equating permanent removal to detention?
Nou, as u sê dat u eintlik bedoel het 'n lang termyn aanhouding, het u geen dokument wat u kan verwys wat dan aandui dat u bedoeling was aanhouding vir 'n lang termyn.
Lady, I object. The question was asked and the question was answered. It's exactly the same question.
Yes, Ms. Buthelezi.
My lady, no further questions.
Is there perhaps another counsel who's maybe on the line and has a question for the witness? Doesn't look to be the case. Mr. Van Zyl, any re-examination?
Oh, my lady, there's no. Just a second, my lady. No, I have no further questions or any re-examination. Thank you, my lady. The witness just requests to just convey something to the court.
Yes, he can do so.
Ik kan wat u wens om aan die hof oor te dra, kan u oordra.
Edele, baie dankie vir die geleentheid. Ek het die behoefte om vir die tolk te sê baie dankie. Hy het sy werk professioneel, korrek en met groot waardigheid gedoen en hy het gehelp in hierdie verrigtinge. Ek dink dat hy verdien daarvoor beloning of vergoeding of ten minste dat iemand vir hom baie mooi dankie sê op 'n professionele manier.
My lady, I'm saying thank you, and I want especially to thank the interpreter because he did his job very well and very professional, and he was a great help to the proceedings in Kaso. My wish is that someone will thank him, remunerate him, or give him some incentive as it pleases the court.
Yes, I hope someone is listening to that plea. Like you, Mr. Wabani.
Lady, I assume that's the nicest words that interpreter had to interpret in his life.
Yeah, I can imagine. Thank you to you too, Mr. van der Westhuizen, for making the time to come and enlighten the court about what is concerned in these proceedings. Mr. Gqeberha, I see you have your hand up. Did you want to say something?
Thank you, meneer van der Westhuizen.
Lady, I don't want to say anything. I can't work this thing.
I thought you were going to offer Mr. Wabani something. All right.
The lady, can the court hear me?
Yes, we can hear you.
I haven't got money, my lady.
Okay.
I can't give money.
All right. Thank you so much. Okay.
Ek wil net oordra aan die hof se dankbaarheid teenoor generaal van der Westhuizen dat u bereid was om die hof in te lig om te kom en dat u die hof mooi gehelp het met u getuienis. Die hof wil net dankie sê vir u teenwoordigheid, die wyse van die getuienis en ook dat u ook kon verduidelik rondom sekere aspekte. As it pleases the court, my lady.
For a moment, Mr. Wabani, I thought you were going to thank me. Anyway, thank you very much, Mr. van der Westhuizen. You are excused.
U word dan verskoond, meneer van der
Thank you.
Westhuizen.
Dankie.
Yes, Mr. Gqeberha.
My lady, as per our discussions in chambers, we were under the impression that from an email that Advocate Van Zyl had sent to us that he was available in March, and that is why we recommended the dates from the 23rd to the 27th of March. But Mr. Pushiya has now indicated that Advocate Van Zyl is actually not available. But if you could please get confirmation of that.
Lady, if I can just explain, I'm briefed for a trial that's set down for the whole of the first term next year in the Johannesburg South, the Gauteng South Division of the High Court. I sent that mail this morning. I did not have the dates of the term at hand, and I assumed that more or less in the middle of March it would be end of term. One of my colleagues, was specifically Mr. Sindier, now found out that the term only ends on the 30th of March. Lady, but I don't want to overturn the apple cart. I suggest that we leave the dates as arranged, because it appears to me that it suits everyone. Lady, you would know from experience how long trials like that go. Maybe it doesn't proceed, or maybe it, there's a postponement, whatever the case may be. So my suggestion is that we leave it as it is, and we will amongst ourselves, Mr. Fisher can attend if I'm not available. We will make an arrangement, but we don't want everyone to have to go back to their diaries now and again to look at the date. So Mr. Fisher is present here, and he indicates that either he or Mr. Roos, his partner, will be available if I'm not available. So we can leave the dates as they are.
So are we agreed on the continuation date being the 23rd of March through to the end of that week?
Yes, my lady. We're happy with those and satisfied with those dates, and as arranged, it's in order with us.
Thank you.
My lady, those dates are suitable to us.
May it please the court, my lady, from my side, Sindier, we are also satisfied. Those dates suits us as well.
Good afternoon, Mr. Cillier. Thank you very much. Mr. Schoolman?
May it please the court, my lady. Yes, those dates are also suitable to us, my lady.
Thank you.
My lady, we also confirm those dates on behalf of the families.
Thank you, Mr. Vani. Okay, with that, we will, the proceedings will be adjourned until the 23rd of March 2026. Thank you very much to everybody for your cooperation, for your patience, and for your attendance.
As a court, please, my lady.
Thank you. With that, the court will adjourn.